Thank you for joining us today. Today we look closely into the second chapter of the Slade Gang story, following a dramatic turn of events that saw each member of the Notorious gang convicted in a second trial of very serious crimes and sentenced to life behind bars. A dramatic shift was about to reverberate through the corridors of justice. Today we are about to delve into a tale on unwavering determination, legal prowess, and the pursuit of truth that would leave an incredible mark on the annals of the UK judicial system. On that fateful day, February the 10th, 2015, an appeal was set in motion that would test the very foundations of the English and Welsh Courts of Appeal. Dennis Slade, along with his steadfast comrades, Mr. Pearman and Mr. Baxter, refused to accept their convictions lying down. Fueled by an unyielding belief of their innocence, they embarked on a journey that would challenge not only the allegations against them, but the very integrity of the legal framework itself. Little did anyone anticipate the milestone of legal brilliance, forensic expertise, and unprecedented revelations that would follow. The courtroom became a battleground where the clash of legal titans reverberated through every argument, every piece of evidence, and every testimony. The appeal proceedings were marked by jaw-dropping revelations, previously hidden truths, and the relentless pursuit of justice that pushed the boundaries of the conventional legal strategy. The ramifications of what unfolded next would indeed shake up the entire UK judicial system. As the appeal process unraveled, it became a symbol of hope for those who had lost faith, a testament of the resilience of human spirit, and a stark reminder that the pursuit of justice is a relentless and unwavering endeavour. The UK watched with bated breath as the narrative shifted, as doubts were cast upon once solid convictions, and as the very pillars of the justice system trembled under the weight of the truth-seeking crusade. So, as we venture into the next part of this tumultuous saga, it is not just a documentary, it is a deeper look into the corridors of power, a testament of the power of perseverance, and a living testament to the belief that justice, when sought with unwavering determination, can indeed reshape the very fabric of our legal landscape. As long ago as the 20th of August 2009, after a lengthy trial at Leeds Crown Court before His Honour Judge Hoffman and a jury, each of the appellants, Mr. Slade, Mr. Pearman and Mr. Baxter, was convicted of counts of conspiracy to murder, criminal damage, handling and arson. After that trial, they faced a further trial, along with the appellant Mr. Hudson, on 2 counts of conspiracy to rob and 2 counts of robbery. At various stages, Mr. Baxter changed his plea to one of guilty on 3 counts which he faced, and Mr. Hudson pleaded guilty to 1 count of robbery and 1 count of conspiracy to rob. After that second trial, also before Judge Hoffman and a jury at Leeds Crown Court, Mr. Slade and Mr. Pearman were on the 1st of February 2010 convicted of all 4 counts, and Mr. Baxter was convicted of the remaining count of robbery which he faced. Mr. Slade, Mr. Pearman and Mr. Baxter was sentenced to imprisonment for life on both indictments. In sentencing, the judge made clear that he had considered both indictments together in making his assessment of the dangerousness. He described them as callous, dangerous and ruthless, and engaged in Premier League crime. Mr. Slade was assessed as the leader, with Mr. Pearman and Mr. Baxter described as loyal henchmen. They were sentenced to life terms with consecutive determinate terms of 23 years for the first indictment and 20 years for the second indictment in the case of Mr. Slade, 21 years for the first indictment and 18 years for the second indictment in the case of Mr. Pearman, and 21 years for the first indictment and 18 years for the second indictment in the case of Mr. Baxter. The resulting specified minimum terms were 21.5 years, 19.5 years, and 19.5 years respectively. Time spent on remand in custody being directed to count towards the sentence. A serious crime prevention order was also made against Mr. Slade. Mr. Hudson, who had pleaded guilty at a late stage on 2 counts which he faced, was described by the judge as not being a core member of the gang. He did not attract a finding of dangerousness. He was sentenced to a term of 9 years imprisonment, with time spent on remand in custody also being directed to count towards the sentence. Applications of Mr. Pearman and Mr. Baxter to appeal against their convictions on the second indictment have previously been rejected by this court. All appellants, however, appeal with leave against the sentences imposed on the second indictment, and Mr. Slade, Mr. Pearman and Mr. Baxter also appeal with leave against the sentence imposed on the first indictment. The appeal hearing before us, however, was confined to the appeals with leave to a single judge of Mr. Slade, Mr. Pearman and Mr. Baxter against their convictions of the first indictment. The arguments focused on the convictions of the count of conspiracy to murder. It ultimately was common ground before us that the various appeals against sentence would need to be deferred for further consideration, depending on the outcome of the appeals against conviction on the first indictment, and the appellant, Mr. Hudson, who we gather has now been released on licence, made no objection to the hearing of appeals against sentence being adjourned for this purpose. A great part of the appeals against conviction has concerned the appellant's application to this court to adduce fresh evidence. The fresh evidence is of two kinds. The first relates to CCTV evidence taken with a mobile phone and cell site analysis. It is said that the proposed fresh evidence demonstrates the critical timing shown on the CCTV recordings at Mr. Slade's home at 2 Sandmore Drive was consistently, over the relevant period, some 22 minutes slow, as to compared with real time. When that factor is then also linked to an analysis of a mobile phone usage and cell site and other evidence, the result is, so it is said, that it is shown that some or all of Mr. Slade, Mr. Pearman and Mr. Baxter could not have been in an Audi RS6 car engaged in conspiring to murder at the times and locations forming a central part of the Crown's case at the trial. We note at this stage that much of the argument on this point rested not simply on fresh evidence as such, but also on a redeployment, albeit with what appears to be a fresh analysis and considerable amplification of evidence and arguments available to be advanced at trial. The second relates to voice recognition evidence. Such evidence had been given at trial, but it is said that there have been subsequently been developments in the relevant science such that new evidence in the form of automatic speaker recognition technology, being evidence of kind not previously deployed in the courts of England and Wales, should now be admitted. It is said that such evidence demonstrates not only that the assertion of the alleged conspiracy of voices recorded on the relevant occasions in the RS6 car with the voices of Mr. Slade, Mr. Pearman and Mr. Baxter as advanced by the Crown in trial were in fact erroneous, but also that the presence of the appellants in the car on such occasions can be positively excluded. That, however, is not the only grounds for these appeals. Other grounds are advanced. It is said that the judge should have acceded to the application to discharge for jewellery. It is said that the judge erred in failing to accede to submissions of no case to answer made on behalf of all three appellants at the close of the prosecution's case. It is further said that thereafter in the summing up to the jury was unfair, unbalanced and heavily slanted in favour of the prosecution and against the defence. Very late in the day, an argument was also sought to be raised on behalf of Mr. Baxter to the effect that there was unfair non-disclosure at the trial by the Crown of material said to be highly relevant to the defence's case. At trial, all the defendants were represented by experienced leading and junior counsel. Since the trial, however, there have, for various reasons, been changes in the legal representation, sometimes more than once. Before us, Mr. Slade was represented by Mr. Tim Owen KC, with Mr. Stephen Vullo KC. Mr. Pearman was represented by Mr. Henry Baxland KC, leading Mr. Derek Duffy, and Mr. Baxter was represented by Mr. Kieran Vaughan QC, leading Mr. Aaron Watkins. The Crown was represented by Mr. Paul Greeny KC, leading Mr. Nicholas De La Poa. Mr. Greeny, then a junior counsel, being led by Mr. Robert Smith KC, and Mr. Duffy, had appeared at trial. None of the other counsel appeared before us, or the solicitors instructing them had been involved in the trial. We wish to pay tribute to the meticulously thorough preparation by the legal teams, counsels and solicitors of all parties for the purposes of this appeal, and to the skill and care with which the respective arguments, both written and oral, were advanced in this case, which has raised some issues of considerable complexity. Moreover, by a sensible division of labour in terms of presentation of the arguments, the hearing itself was assisted in being kept within the 3-day time estimate allocated to it. We also wish to pay tribute to the most helpful and convenient way in which the various appeal bundles were presented, and in which all parties cooperated, although we gather that particular credit is due to Mr. De La Poa in this regard. We should say something about the lapse of time which has occurred before these appeals came on for hearing. It is wholly exceptional that an appeal against conviction comes on for hearing before the Court of Appeal, the Criminal Division, some 5 years after the trial, where the applicants for leave to appeal are lodged shortly after convictions. To a very great extent, the delays have been occasioned by various changes in legal representation for the appellants that have occurred from time to time, and the sheer complexity of aspects of fresh evidence sought to be obtained by the appellant since trial, together with associated funding problems. Further, some of the applications for leave to appeal, whether on the first indictment or the second indictment, had in fact been brought out of time, the necessary extensions therefore being granted. In the event, some grounds were then abandoned at various stages, others added. Directions had been previously given by Hughes L.J., the then Vice President of the Court of Appeal and the Criminal Division, during 2011 and 2012, which were not, for various reasons, fully complied with. Even by the beginning of 2014, the cases were still a long way away from being ready, and indeed only then, by direction of the Register of Criminal Appeals, was the representation order extended to Mr. Slade's new legal team to enable it to instruct voice recognition experts and to prepare the new schedules comprising the CCTV and mobile phone and cell site evidence. Final perfected grounds of appeal, superseding all previous grounds, were lodged by the appellants during the course of 2014. Further directions were given at various stages during the year by this court, designed to ensure that the matter came on for hearing in a properly prepared state by the end of the year. In the result, as we have indicated, the cases, as presented, were very well prepared and very well focused. We think it is important to provide some context for the first indictment by briefly summarising the facts relevant to the second indictment, which relate to a period of time to some extent spanning or preceding the relevant period for the first indictment. To do so will also help explain why the trial judge described Mr. Slade, Mr. Pearman and Mr. Baxter as Premier League criminals. Put shortly, the position was this. Mr. Slade, Mr. Pearman and Mr. Baxter were undisputably close associates. Between January 2007 and March 2008, they conspired to rob drivers and guards of cash in transit vans. A number of premises were targeted. Cars were stolen to assist in their activities, and they engaged in frequent surveillances of target sites or deliveries. That constituted the count of conspiracy to rob, which was count 1. On the 8th of March 2006, a stolen low loader blocked the path of a securities cash in transit van just before it reached its depot in Woolston near Warrington. A stolen agricultural tractor then repeatedly smashed its loading arm into the van's cash storage compartment. Over £1 million was stolen by men wearing masks and equipment with crowbars. The low loader and the tractor were then set on fire with petrol, and other vehicles were used to effect to get away with the cash. That was count 2. On the 12th of December 2007, a telescopic loader was stolen from a building site. On a later date, it was used to smash a hole in the wall in a post office, at which staff, mainly female, were present. 2 masked men ran through the gap created and terrorised the occupants. 4 security boxes were taken, although £50,000 was left in an open safe. A stolen car was used to effect the getaway. Some 45 minutes later, Mr. Hudson and Mr. Pearman were observed by police to hide the car at a garage in Arncliffe Grange in Leeds. That was count 3. As for count 4, that was a count of conspiracy to rob. The conspirators planned between the 13th of December 2007 and the 21st of January 2008 to rob a Sainsbury's store in Colton Retail Park in Leeds, where it was known that some £500,000 was destined for ATM machines. They were observed engaging in regular surveillance. By January 2008, they had gained access to the roof and thence to an unused part of the premises, and were preparing to smash through it into the ATM room. However, sounds of drilling were heard by staff on the 29th of January 2008, and the police were summoned. The would-be robbers fled, but their activities on the roof area were revealed. Mobile phone and cell site evidence featured prominently at the second trial, as well as observations by police of the accused. It appeared at the first trial Mr. Slade was, through his counsel, to advance his alleged involvement in such activities as charged in the second indictment as a potential explanation for some of the activities which featured in the first trial, and in order to rebut the charge of there being a conspiracy to murder. It was common ground that the matters which ultimately gave rise to the indictment for conspiracy to murder and related charges first came to the attention of the police as a result of the observations kept by the police of the movements of Mr. Slade, Mr. Pearman and Mr. Baxter, and others associated with them in connection with the suspected serious crime, which revealed the robbery matters. Such surveillance included the use of covert audio and tracking devices placed in cars connected with the appellants or their associates. The prosecution, in fact, identified the intended victim of the alleged conspiracy to murder as a man called Ralph Roberts. He resided in the East End Park area of Leeds. He was also closely connected to a local pub called the White Horse. Mr. Roberts himself had a strong connection with criminal activity and had an extensive criminal record, including for violence. He subsequently refused to cooperate with the police and did not give any evidence at the trial. Mr. Roberts resided at an address in York Road, his home backing on to Dawlish Crescent. He was known frequently to park his car, a silvery green Toyota Aventis, outside. On the evening of the 4th of March 2008, in the hours of darkness, 4 men drove up outside Mr. Roberts' home in Dawlish Crescent. They were in a black Audi RS6 car. It had been stolen a considerable time previously. Some of the men got out of the car and smashed the windows of a Vauxhall Vectra car parked in the street, belonging to a man called Mallock. He was the neighbour of Mr. Roberts. Mr. Mallock looked out of the window and saw the RX-6 being driven off at speed. The police had been waiting nearby. They intervened when the sounds of the breaking glass, which were picked up on a covert audio device placed in the RX-6, caused them to think that shots had been fired. In the event, the RX-6 car and the men in it were not apprehended, but the police at the time also surrounded a black Audi A4 car, which previously had been parked in Ivory Crescent with its engine running some 320 metres away from Mr. Roberts' home. At around the time, the RS6 car had been driven up near to Mr. Roberts' house. Inside the A4 car were Mr. Slade, Mr. Pearman and Mr. Baxter. The evidence was that the A4 car had been driven up to the area at the same time as the RS6 car, and, even if not taking an identical route, had been in virtual convoy with it, as the Crown was to put it. The police were armed. When arrested, none of the 3 appellants resisted. No weapon of any kind were found on them or in the A4 car itself. However, subsequent examination showed that within the car were, among other things, a black bin liner bag containing clothing and a pair of binoculars, and a rucksack of a colour and kind Mr. Slade had been observed often to carry, containing dog and cat repellent and a frequency recorder, a Tupperware box containing 4 car keys, and an electric fob and a yellow card. Mr. Slade's fingerprints were on the box, gloves, a magnet, a plastic bag containing adhesive straps with 2 blades and a tracker Mach 4 with batteries attached, and which had Mr. Slade's fingerprints and DNA on it. The tracker was found on the rear near side floor where Mr. Pearman had been sitting. When arrested, Mr. Slade, who had been sitting in the front passenger seat, had been observed turning to place something at the feet of where Mr. Pearman had been sitting. The appellants were taken to separate police stations. A mobile phone attributed to Mr. Baxter was found in the car, and mobile phones were also seized from Mr. Slade and Mr. Pearman. All had their batteries removed, and, as the Crown was to say, with the perceived view of frustrating any subsequent cell site analysis. In this regard, there was evidence that Mr. Pearman, from previous criminal proceedings, had had experience of the use of such cell site evidence. Further, a mobile phone jammer and other anti-avoidance materials were subsequently found at Mr. Slade's house, and there was evidence of accessing by computers belonging to Mr. Slade and Mr. Baxter of anti-avoidance and anti-jamming techniques. Literature relating to the mobile phone jamming was also found in Mr. Baxter's Mercedes ML car. At 1923, before the windows of Mr. Maluk's car was smashed, the police had alerted Mr. Roberts, and he had fled the area. At 1942, after the smashing of the car windows of Mr. Mullock's car, the RS6 had been observed to stop at Rushwood Gardens nearby. A young witness saw 4 men get out of the car. A man on a motorcycle then drove up. The driver of the RS6 gave him something bulky, which had been hidden under his jacket, got onto the motorcycle, and the motorcycle was then driven away. The remaining 3 men were seen and heard by witnesses to be arguing. One was heard to say the words to the effect, "My DNA and fingerprints are all over it." The RS6 was then set alight with petrol before the 3 men ran off. Subsequent examination of the burned out RS6 showed it to be a stolen car. Its number plates had been removed. In their place were double-sided adhesive strips, similar, although not identical, to those found in the bag in the A4. A magnetic disc was found in the debris, and a like kind to that fixed to the tracker, the Mach 4, found in the rear near side footwell of the A4. The Crown's case was that the men in the RS6 were operating in conjunction with the appellants in the A4, which had been borrowed from a car leasing firm that very day. The actual period of the alleged conspiracy to murder was stated to be from the 21st of January to the 4th of March 2008. The Crown's case was that the plan was to lure Mr. Roberts into the street when the car windows were smashed, when he would then be killed. An alternative suggestion by the Crown was that, at the least, Mr. Roberts was to be lured into the street or otherwise distracted with a view to the tracker being affixed to Mr. Roberts' car in order to assist with his subsequent killing. The Crown's case had a number of strands. Apart from clear evidence of association between the 3 appellants, a considerable amount of evidence was adduced which was designed to show that they were associated with the RS6. The car had been stolen on the 27th of September 2005 from an address in Leeds. Its identity thereafter was variously changed by the application of 2 sets of clone number plates, lawfully registered to the other Audi RS6 cars. There was an abundance of evidence to link the appellants to the RS6 in 2007. Police observation also showed that the RS6 had been kept at various locations, including 2 lock-up garages in Arncliffe Grange and Unit 9, Rifford Business Park at 6 Primrose Court in Primley Park View, and Highthorn Court on Shadwell Lane. Recording devices had been installed by the police at these locations for the purposes of the investigations connected with the suspected serious crime, as well as at other locations. Further tracking and recording devices were covertly affixed by the police to the RS6, and also to a Peugeot and a BMW connected to the appellants. Although there had been observations on a number of occasions of Mr. Pearman and Mr. Baxter in the RS6 on false plates, up until the end of 2007, there was no such observations maintained by police thereafter. However, Mr. Baxter was, on an occasion, on the 26th of February 2008, observed in his Mercedes ML car parked a few metres away from the RS6, itself parked at Primrose Court. Further, when the Mercedes ML was subsequently searched following arrest of the appellants, a key to the lock-up garage in Arncliffe Grange was found in it. All 3 appellants were linked to the lock-up garage in Rifford Business Park, where the RS6 had from time to time been kept. Mr. Pearman's fingerprints were on the tenancy agreement for the unit. A key to the garage padlock was found in Mr. Baxter's Mercedes ML along with other keys. A box found in the A4 car, on which were Mr. Slade's fingerprints, was a fob for a roller door of a garage at Rifter Business Park. Another vehicle connected both to the RS6 and to the appellants was a Toyota Hiace van. That vehicle had been brought for cash on the 9th of August 2007 by two men who wore motorcycle helmets throughout the acquisition transaction. A false name and address were given for the buyer. Thereafter, the vehicle was extensively adapted in a manner consistent with an intended use for surveillance. The Crown's case was that this was done at the behest of Mr. Slade, that accorded with the manual for such vehicle surveillance adaptations found in Mr. Slade's Lincoln car at his home after his arrest. The search of Mr. Slade's house, as we have said, also found other items such as a mobile phone jammer. In addition, it may be added, to a bulletproof vest which was found under his bed. The Toyota Hiace was operated under false plates, cloned to authenticate plates of another Toyota Hiace lawfully kept by its owner in Merseyside. A false plate fixed by magnet to the vehicle was in due course found to have Mr. Pearman's prints on it. In addition, a key to the Toyota Hiace was later found in Mr. Baxter's Mercedes ML. Further, there was evidence that the vehicle had been observed on a significant number of occasions to have been used by all three appellants. On occasions in 2007, moreover, the Toyota Hiace was observed in a convoy with the RS6 with Mr. Pearman and Mr. Baxter, if not Mr. Slade also inside. Latterly, on the 1st of March 2008, the Toyota Hiace with the three men inside it drove repeatedly and slowly around a number of streets in the East End Park area, including Dawlish Crescent and an area close to the White Horse pub. It was then driven to Swarcliffe, where Mr. Pearman lived. On the 3rd of March 2008 in the evening, three men, against the appellants of the Crown's case, were in the Toyota Hiace in the Dawlish Crescent area. They were under police observation. Two of the men in the vehicle got out of the Toyota Hiace and walked around, wearing hats and with their faces concealed by scarves. A considerable amount of time at trial was devoted to evidence of mobile phone use and cell site analysis. Detailed and complex schedules were prepared. A number of mobile phones variously attributed to Mr. Slade, Mr. Pearman and Mr. Baxter were subject to such analysis. It is not necessary for present purposes to go into details, although we will have to come back to the point when considering Mr. Vullow's submissions. Suffice it is here to say that the Crown's case at trial was that such evidence was consistent with the alleged conspiracy and that the cell site analysis and tracker evidence accorded with the movements of the appellants in furtherance of that alleged conspiracy. It was necessarily accepted that the cell site evidence could only show the approximate location of the phone in question. It could not necessarily identify the individual with such a phone. The Crown also adduced evidence of the recordings of the CCTV cameras at Mr. Slade's house, of which there were 4 with a centralised control. These showed, amongst other things, Mr. Slade during this period being variously picked up and dropped off at 2 Sandmoor Drive by the Mercedes ML associated with Mr. Baxter. In this regard, the evidence gave rise to an important issue. Police evidence was adduced relating to their attendance at 2 Sandmoor Drive later on the 4th of March 2008, after the appellants had been arrested. That evidence, if not entirely precise, established that on that date the clock on Mr. Slade's CCTV showed a time some 22 minutes slower than real time. That matter played an important part in the trial, and has in turn played an important part in the arguments before us. The CCTV evidence taken from the cameras at Mr. Slade's house in Sandmoor Drive was to the effect that Mr. Baxter, in the Mercedes ML car, would regularly pick up Mr. Slade, with Mr. Slade often taking with him a rucksack and a bag, and then return him in the same car some time later. It was common ground at the trial, as we were told, that the Mercedes MR was always being driven by Mr. Baxter. A very important part of the Crown's case trial also related to covert audio recordings by probe of conversations between the male occupants of the RS6 car on various occasions in the conspiracy period. The Crown's case was that such conversations were variously to be attributed to Mr. Pearman and Mr. Baxter, and also on 2 occasions Mr. Slade. In brief summary, during the days of the alleged conspiracy, the position was this. On Friday the 22nd of February 2008, there was a regular phone contact between Mr. Pearman and Mr. Baxter. The RS6 was observed to leave Primrose Court, where it had been parked at 1910. There were, as recorded by the probe, conversations between the men in the car, asserted by the Crown to be Mr. Pearman and Mr. Baxter, but disputed by the defence. There were discussions, as recorded, suggestive of a gun being stored at Fir Tree Woods, an area in which the appellants had links. At 1950, the car had entered the East End Park area and toured around. At one stage, one of the men, said by the Crown to be Mr. Pearman, said, "Den's fucking about. All we were supposed to do was grab the fucker." The Crown's case was that the reference to Den was a reference to Dennis Slade. At 1953, the CCTV cameras at Dennis Slade's home on the CCTV clock timing showed Mr. Slade being dropped off at his home in Sandmore Drive by the Mercedes ML. On Saturday the 23rd of February 2008, there were further contacts between the appellant's phones. The RS6 was driven away from Primrose Court at 1813. Then there were no such calls. After going to Fir Trees, the car started to tour around the East End Park area at 1850. There were 2 men inside the car. They were said by the Crown to be Mr. Pearman and Mr. Baxter. The men were recorded as referring to looking for something silvery green, which was in fact the colour of Mr. Roberts' Toyota Aventus. There was also reference to waiting near a house, said by the Crown to be Mr. Roberts' house. There was then recorded a conversation which plainly indicated the presence of a gun in the car. There was a reference to cocking the gun, with recorded clicking sounds, and a request from one man to another not to point it, and to avoid blowing holes in the back of the seats. There was also a reference to a man called Damon seeing the car. The Crown's case was that he was Damon Tremble, who lived on the Fir Trees estate, an associate who was either in another car or in the street acting as a lookout or backup. There was effectively unchallenged evidence from an expert called by the prosecution that all this recorded conversation was consistent with the presence in the car of a double-barreled sawn-off shotgun. There was evidence that the RS6 continued touring the area that evening. At one stage, as the tracker indicated, it stopped at Dawlish Crescent at 1912 and then did so again later. One of the men was recorded as, amongst other things, referring to "no one would know the weapon if they were stood here." Another said, "We'll just have to keep coming every effing night because the clocks are due to go forward, aren't they?" On Sunday the 24th of February 2008, the RS6 was collected at 1744. Mr. Slade was picked up from his home by Mr. Baxter's Mercedes ML at 1802, according to the timing on the CCTV. From 1813, the RS6 toured around the East End Park area. It stopped at Dawlish Crescent for some 12 minutes. There were then clicking sounds recorded, and a reference to hiding it. The car drove off and then returned to Dawlish Crescent. There was reference to "that's his house over there," and the car drove off. At one stage, at 8 o'clock, a car door was heard to open and close. According to the Crown, Mr. Slade, previously picked up by Mr. Baxter at 1802 on the CCTV time, was then in the car with Mr. Pearman and Mr. Baxter. A voice attributed by the Crown to Mr. Slade was heard to say, "Can't believe we didn't have the thingy, he's straight out of that house." A voice attributed to Mr. Pearman then said, "Only time we didn't have it with us, man." The RS6 was returned to Primrose Court at 2056, having travelled via Fir Trees. Mr. Slade, according to the timing on his CCTV, was dropped back at his house at 2142. On Monday the 25th of February, the Mercedes ML collected Mr. Slade carrying a blue bag and a bin liner at 1656 from Sandmore Drive, according to the CCTV timing. The RS6 was in Fir Trees area that evening. Recorded conversations said to be Mr. Pearman and Mr. Baxter were suggestive of an anxious search by someone for something concealed in a wood. The Crown said it was a gun. The RS6 was said to be occupied by Mr. Pearman and Mr. Baxter, then drove to Dawlish Crescent, arriving at 1921. There were recorded references to cartridges and their colours and weight of the shot and so on. Undisputed expert evidence indicated that the remarks could only be suggestive of a conversation about shotguns and cartridges, with the heaviest weight of shot. The car drove around. there was a reference to the associates, including Damon. At a later stage, the car drove outside a pub. One voice said to a man on the phone, "Now, when he comes out, see if his bird and that's with him." There was another conversation indicative of a gun having jammed. A voice attributed to Mr. Baxter said, "Don't know how lucky they have been." Another voice said, "Wrap it up, don't touch it," and "fucking lethal that though." The RS6 was then returned to Primrose Court. Mr. Slade was observed to return to his home later with the bin bag liner. On the 26th of February, Mr. Baxter was seen parked in his Mercedes MR at around 15:30, very close to the RS6 at Primrose Court. The Crown was to say that he was checking on the RS6. The defense suggestion was that he may have simply been taking a shortcut on that particular journey. At 18:30, according to Mr. Slade's CCTV, he was collected from Sandmoor Drive by Mr. Baxter in the Mercedes MR. At that stage, the tracker evidence indicated that in fact the RS6 was, if the CCTV time was right, at East End Park, or if 22 minutes slow, it was in the centre of Leeds. The Crown's case had been that the RS6 had been tailing Mr. Roberts' Toyota Aventus that evening. At 18:44, the RS6 was in the Eastgate area of Leeds. According to the Crown, Mr. Pearman and Mr. Baxter were in it. Recorded conversations of the men in the car and the automated number plate recognition camera identifications were suggestive of Mr. Roberts' Toyota Aventus being followed by the RS6. There were then calls between the phones of Mr. Pearman and Mr. Baxter at this stage, which the defence said was entirely inconsistent with them being in the car together. The prosecution was to suggest that their phones were not in the car, even though Mr. Pearman and Mr. Baxter, on their case, were, and that the phones were being used by others. There were also texts from that evening, from 1938, from Mr. Baxter's phone to a lady named Div, indicated from the evidence of the person with the phone not being in the RS6. It was said by the prosecution that later on Mr. Slade got into the RS6, Mr. Roberts having been lost. A voice attributed by the Crown to be Mr. Slade is heard saying, "Fucking bastard, I wish we'd clipped this one last night, know what I mean?" He went on, "I think the best thing to do, Rich." The Crown say he was talking to Richard Pearman. A defence disputed by the word Rich, as opposed to mate, had been used at all. The car was then parked for the night at Primrose Court. Mr. Slade himself was returned home at a later stage in Mr. Baxter's Mercedes MR. On Wednesday the 27th of February 2008, Mr. Slade was picked up at Sandmoor Drive according to the time on the CCTV by the Mercedes MR at 16:43. At around 18:30, the RS6 entered the East End Park area. According to the Crown, Mr. Pearman and Mr. Baxter were in it. As it entered Dorless Crescent, there were sounds and conversations indicating that a gun was in the car and that there were difficulties with it jamming. A voice attributed by the Crown to be Mr. Baxter said, "I didn't know you were going to fucking kill the cunt. You didn't tell me that, did you?" The answer attributed to Mr. Pearman was, "He wants him, didn't he?" A little later, the voice attributed to Mr. Baxter said, "I'm not bothered as long as you didn't thingy the I thought you were going to give him one." The prosecution said that all this plainly showed an intention to kill, and that the actions were instructed by another, Mr. Slade as it is said. The RS6 was parked in Primrose Court at 1956. It remained there until the 2nd of March. According to the CCTV timing, Mr. Slade returned home with a blue bag at 23:06. On the 28th and 29th of February, the RS6 was not used. On Saturday the 1st of March 2008, the RS6 was again not used. However, the Toyota Hiace, with 3 men in it, the appellants, as the prosecution said, was used, as we have mentioned previously, as the prosecution said, in place of the RS6. There was also much telephone traffic that day between the appellants' phones, although not when the Toyota Hiace was in use by the 3 men. On Saturday the 2nd of March 2008, the RS6 was not used in the daytime. However, in the evening, the associate of the appellants, called Damon Tremble, with another man, drove in Hudson Silver Audi to Primrose Court, where he jump-started the RS6 and then drove it to Highthorn Court off Shadwell Lane, where at 20:03 it was parked. On Monday the 3rd of March, there were again many calls between the appellants' phones. As we have said, The Toyota Hiace was again in use on this day. The phones then were not being used. Mr. Pearman was identified as the front seat passenger in it at 22:06. According to Mr. Slade's CCTV, Mr. Slade was driven home to Sandmore Drive in Mr. Baxter's Mercedes ML at 22:29. This leads up to the final day, the 4th of March 2008, where the appellants were arrested in the circumstances described above. As for the Audi A4 that had not previously featured, it had been collected that day from a company called Yeadham Motors by Mr. Pearman and Mr. Baxter, who had driven to Yeadham Motors in the Mercedes ML in the afternoon. The three appellants met at Hollywell Lane, Shadwell, where the Mercedes ML was left. At 19:03, there was a call from Mr. Baxter's phone when the RS6 was being removed from Highthorne Court. The A4 was then driven to the East End Park area. At around the same time, the RS6 was being driven there, as the Crown was to say, in virtual convoy with the RS6, and also following a similar route to that taken by the Toyota Hiace on the 3rd of March. When interviewed over a number of occasions, Mr. Slade and Mr. Baxter made no comment. Mr. Pearman gave answers denying any involvement in any conspiracy to murder. In the course of his answers, he was to say what the prosecution stated was a clear lie, that he did not even know anyone called Damon. As Mr. Greene observed, the appellants conducted a highly tactical defence. Not only did Mr. Slade and Mr. Baxter make no comment in the interview, but none of the appellants, as we're told, served any defence statement. After they had failed in their submissions of no case to answer, none of them gave any evidence. The position of the appellants at trial was, amongst other things, that neither Mr. Pearman nor Mr. Baxter were shown to be in the RS6 at any stage during the indictment period. Mr. Slade likewise denied being in an RS6 on two occasions, the 24th and the 26th of February, when he was said to have been in it. The prosecution necessarily had to concede that none of the appellants were in the RS6 on the evening of the 4th of March 2008, when the windows of Mr. Morlock's car were smashed and the RS6 thereafter burnt. It seems not to have been seriously disputed at trial, at all events on behalf of some of the appellants, that there was ample room for drawing of an inference that the three appellants were engaged in some kind of criminal joint enterprise. The same approach has been pragmatically taken on behalf of all the appellants for the purposes of this appeal. What is stressed by the appellants, however, is that that is not enough. What was alleged by prosecution was conspiracy to murder, with related counts, to which the appellants are alleged to be a party, and it is that which the prosecution had to prove to the criminal standard. The trial commenced on the 19th of May 2009. Much of the prosecution's evidence was directed at mobile phone and cell site analysis, and the tracker and probe evidence, and much evidence also was directed at proving a connection between the three appellants and the RS6 and the Toyota Hiace and associated premises. The only positive case advanced at trial by any of the three appellants, by way of explaining their presence in East End Park area in the A4, if not also previously in the Toyota Hiace, was advanced on behalf of Mr. Slade. It was said, although not, of course, said by him in interview, that he was there to collect a debt from a man called Forrest. Mr. Pearman and Mr. Slade were said to be there supporting him, although it seems that they themselves at trial through counsel advanced no such positive case. Mr. Forrest and his partner were called at trial on behalf of Mr. Slade. It would seem that their evidence, for whatever the jury made of it, gave rise to more questions than answers. It was also, for example, left unexplained why, if that were the real explanation, the appellants had various items in the A4 when arrested. There had been no direct evidence of observation of any of the appellants being in the RS6. At the time, the various conversations were recorded making reference to a gun, cartridges, and killing. In this regard, however, the Crown adduced the evidence of a voice recognition expert, Mrs. Elizabeth McClelland. Mr. Slade had obtained a report of the voice recognition expert, Mr. Martin Duckworth. Mr. Baxter had obtained a report of Dr. Frederica Holmes, and Mr. Pearman had obtained a report of Professor Peter French, assisted by Mr. Harrison. In the result, neither Mr. Duckworth nor Dr. Holmes was called. As the jury were informed, they had reached an agreed position with Mrs. McClelland. In the case of Mr. Slade, it was stated that, with regard to one recording, hold all 55, no identification was possible. In other respects, it was agreed that the reports did not conflict. This agreement was made to the effect that sections of the recorded passages for the 26th of February 2008 were consistent with being spoken by Mr. Slade, with, as Mrs. Cleland said, moderately distinctive features. Consistency was, however, such as potentially to extend to thousands of other men's voices. It was stressed, at all events by the experts, that the opinions had to be used in conjunction with all the other evidence. In the case of Mr. Baxter, the joint finding, by reference to the selected recordings, was one of consistency. However, Dr. Holmes found no levels of distinctiveness, whereas Miss Cleland found that some features might be regarded as moderately distinctive. As to Mr. Pearman, by the time of his final report, Professor French, in contrast to Mrs. Cleland, found no consistency, and he found it very unlikely that the speaker identified by the Crown as Mr. Pearman was Mr. Pearman, although it was a remote possibility. He gave evidence at trial to that effect. Dr. Fawkes, also in Professor French's consultancy, agreed that it was very unlikely that Mr. Pearman was the speaker in questioning recordings. In the course of cross-examination, Mrs. Cleland, in fact, had seemed to withdraw any attribution of at any rate one of the questioned recordings to Mr. Slade. However, she then withdrew this apparent concession in the re-examination and maintained that there was low-level consistency. She accepted, however, that consistency could mean consistency with thousands of voices. She also accepted that moderate distinctiveness was of limited assistance in voice identification. She further accepted that if independent evidence showed that one of the defendants was not in the car when said to have been speaking on the recording, then that would indicate that such defendant was not speaking then, or on any other occasion attributed to that same defendant by the voice recognition device. Overall, the outcome of her oral evidence was such that Mrs. Cleland's evidence was strongly criticised by the defence. At all events, the prosecution were in no position to say, and did not say, that the voice recognition evidence of Mrs. Cleland was in itself, if accepted by the jury, capable of proving the presence of the appellants in the RS6. They also relied on her evidence, along with all of the other evidence, as supporting an inference of such presence on those occasions. We discuss Mrs. Cleland's evidence at trial in more detail later in this judgment. On the 22nd of June 2009, the judge rejected an application to discharge the jury. On the 2nd of August 2009, the judge handed down a written ruling rejecting the appellant's respective submissions, themselves made primarily in writing, of no case to answer. The judge commenced his detailed summing up on the 12th of August 2009. By that time, the jury were reduced to 10 in number. As we have said, the jury convicted on the 20th of August 2009. We then turn to the grounds of appeal. We will take them not entirely on the order in which they were presented to us. We are not impressed by this ground. Some 6 weeks after the trial had started, the court was informed through an usher that one of the jurors, Miss Jones, had attended a social function the previous weekend. She there had met Leah Gatt, who she learned was a cousin of Mr. Slade. Mrs. Gatt, when she was told that Mrs. Jones was doing jury service, made reference to the fact that "our Dennis is up." Mrs. Jones then removed herself from the conversation. The judge caused Mrs. Jones to be brought into court. She said that she did not know Mr. Slade or any of the co-accused, but she knew that Mr. Burley, Leah Gatt's father, had been arrested on a number of occasions by her own father-in-law, a police inspector. She had not previously realised that Mr. Slade was part of the Burley family. She also said that she knew that Mr. Burley's son, Leah Gatt's brother, had been shot dead. She made clear that she was not comfortable with remaining on the jury. She was asked if she had anything to say about this to the other jury members. She said that 3 of them had asked why she was subdued, and she said she couldn't really speak about it, although one of them had been pressing, and she had answered that somebody she knew was the cousin of one of the defendants. On further questioning, she indicated that she had mentioned Mr. Burley to 3 of the jurors, and had said how his son had died and that he had been arrested by her father-in-law. The judge then, after discussion with the counsel, had all of the other jurors brought to court individually, not as a group, and questioned each of them about what they had heard from Mrs. Jones. One said that Mrs. Jones had just mentioned that her friend was related to the defendant, presumably Mr. Slade. Another said Mrs. Jones had mentioned a friend whose cousin was on trial. That juror had only overheard part of the conversation and confirmed that he had heard nothing to compromise his position as a juror. The other jurors said that they had heard nothing at all from Mr. Jones. One had heard her say that a friend of hers was related to Mr. Slade, but nothing else. Another again had overheard part of the conversation in which Mrs. Jones had mentioned something about a friend or possibly a cousin. The judge was then invited to discharge the entire jury, he having already agreed to discharge Mrs. Jones. He declined to do so. He found that none of the remaining jurors knew anything to disadvantage the defendants. The judge said that he was entirely satisfied that the remaining jurors had in no way been tainted, either directly or indirectly, by anything that they should not know. Mr. Vaughan, who led the appellant's arguments on this point, said that there was an appearance of bias, given that the circumstances and applying the test set out in Khan Hanif 2008. He also submitted that the account that Mrs. Jones had given to the judge was not reconcilable with the account given by the jurors, and that on Mrs. Jones' account, at least 3 other jurors knew what she knew, in particular about the Burley family, its criminal involvement, and the connection with Mr. Slade. We reject this argument. The judge had questioned all the jurors in the light of what Mrs. Jones had said. He was entirely satisfied, having regard to their answers, that they in fact knew nothing potentially adverse to the defendants. In our judgment, he was entitled to draw a conclusion on the evidence which he had heard. In consequence, he was entitled in his direction to decline to dismiss the entire jury. This ground accordingly fails. In the course of directions given earlier in 2014, this court had, in order to achieve finality and clarity, directed the appellants to lodge final perfected grounds, superseding all previous versions of the grounds. This was done. However, shortly before the appeal hearing, Mr. Vaughan indicated that he wished to raise further grounds on behalf of Mr. Baxter. This was to the effect that, shortly before the conclusion of the trial on the first indictment, the prosecution had disclosed material in the second indictment proceedings. This related to mobile phone usage and cell site analysis on the part of Mr. Baxter, which the Crown was potentially going to use to demonstrate Mr. Baxter's involvement in robberies and conspiracy to rob. It was set out in the mobile phone and cell site analysis report served by the prosecution. It is now said that this might tend to show that Mr. Baxter was not the kind of person not to use his telephone at relevant times if engaged in conspiracy to murder, and also might tend to show that he was not the kind of man to create a false alibi by giving his phone on occasion to others. This is wholly speculative. Mr. Baxter had not at any stage even pleaded guilty to any count of the second indictment. His eventual pleas were, in fact, very late in the day. Moreover, Mr. Greenery pointed out, Mr. Baxter would have known what use he had made of his mobile phones. He did not need the prosecution to make his case for him. Further, whilst it is asserted that such non-disclosure deprived the defence of an opportunity to decide whether to rely upon the disclosed report at the first trial, it is entirely speculative as to just what reliance could meaningfully have been so placed. Yet further, how such material could meaningfully be deployed at the first trial was problematic on any view. This proposed new ground is perhaps revealing the acutely tactical and opportunistic way in which these appellants ran their cases. At all events, this proposed further ground is entirely lacking in the substance that would have been needed to justify this court even entertaining it at such a late stage. Since it seems to us to be devoid of merit, and since it raises so unacceptably late in the day without proper explanation, we reject it without more ado. We refuse leave to amend the grounds to add to it. As we have said, a submission of no case to answer was made on behalf of all 3 appellants at the close of the prosecution's case. It seems that the retrospective submissions were made primarily in writing, and this court has seen a number, although not all, of such written submissions as presented to the trial judge. The judge, in due course, rejected the submissions of no case to answer by full written ruling dated the 10th of August 2009. We were addressed at some length of the applicable principles, but there was no real dispute before us about them, and we thus need not enter into a detailed exercise here. The bedrock authority remains Galbraith 1981, in context in particular of a case mainly founded on circumstantial evidence. We were also referred to the decision of a constitution of this court in G&F 2012. In this course of giving the judgment of the court, Atkins L.J. reviewed a number of relevant authorities. Having done so, he summarised the position at paragraph 36 of the judgment in this way. We think that the legal position can be summarised as follows. In all cases where a judge is asked to consider a submission of no case to answer, the judge should apply the classic or traditional test set out by Lord Lane CJ in Galbraith, where a key issue in the submission of no case is whether there is sufficient evidence on which a reasonable jury could be entitled to draw an adverse inference against the defendants from a combination of factual circumstances based upon evidence adduced by the prosecution. The exercise of deciding that there is no case to answer does involve the rejection of all realistic possibilities consistent with innocence. However, most importantly, the question is whether a reasonable jury, not all reasonable juries, could, on one possible view of the evidence, be entitled to reach that adverse inference. If a judge concludes that the reasonable jury could be entitled to do so, properly directed on the evidence, putting the prosecution's case at its highest, then the case must continue. If not, it must be withdrawn from the jury. This was accepted before us, for the purposes of this appeal, as a convenient summary of the correct legal approach. That the Crown's case was essentially a circumstantial one is plain. It had, as we have already said, a number of different, albeit linked, strands. The conversations recorded in the RS6 provided evidence to the jury of a conspiracy to kill. As to the questions of whether the appellants were party to such a conspiracy, there were, among other points, these factors. First, there was clear evidence of regular association between Mr. Slade, Mr. Pearman and Mr. Baxter. Second, there was an abundance of evidence of association between them with both the RS6, a stolen car frequently used with false number plates, and the Toyota Hiace, a vehicle converted into a surveillance vehicle and frequently used with false number plates, as well as their association with the premises where they were stored, as evidenced by the finding of the fob keys and so on. Third, there was the evidence of their use of the Toyota Hiace, adapted for surveillance purposes, sometimes in conjunction with the RS6. Fourth, there was the evidence of the RS6 being regularly in the East End Park area during the period of the alleged conspiracy, and also, on occasion, being involved in what could only be concluded to be the tailing of Mr. Roberts' Toyota Aventus. Fifth, there was evidence that the Toyota Hiace, with 3 men in it, being in the East End Park area when the RS6 was not being used on the 1st and 3rd of March 2008. Fifth, there was evidence of the A4 in effect to going into the East Park area in what could only be said to be a virtual convoy with the RS6 on the 4th of March 2008 itself. Sixth, there was indisputable evidence that the 3 men were arrested in the A4 on that date when just parked 320 meters or so from and at the same time as the incident involving the men in the RS6 car damaging Mr. Morlock's car in the street outside Mr. Roberts' house. Seventh, there was evidence of trackers, magnets, and other potentially incriminating items found in the A4 car at the time, along with mobile phones with the batteries removed. Eighth, there was the conduct of the 4 men in the RS6 burning the car and then departing in circumstances witnessed by the boy. Ninth, Mr. Slade and Mr. Baxter gave no comment interviews. There were various other matters as well, which we need not rehearse here. An important feature of the Crown's case, of course, necessarily was the content of the conversations recorded by the probe of the men inside the RS6 on various occasions in this period. As we have summarised above, this was of no particular importance. because the Crown's primary case was not, of course, simply in some unspecified form of criminal joint enterprise or conspiracy. The Crown's case was that the three men were engaged in criminal conspiracy to murder, the postulated victim being Mr. Roberts. In this regard, the recorded conversations with their reference to the gun, the clipping and the gun jamming, and the heavy duty cartridges and so on, all covered by evidence adduced by the prosecution, spoke for itself. It could properly be inferred that those conversations indicated a conspiracy to murder. Furthermore, there was evidence from those conversations which the jury could accept that two of the men as recorded were acting on instruction of the other. Yet further, there was evidence from these conversations which the jury could accept as reference to Den or to Rich. The appellants at trial were, it is true, in a position to say that there was no direct observation of the appellants in the RS6 after the end of 2007, and no doubt also were in the position to mount an argument that the RS6 was to be regarded as it were, a pool car for general use by the criminal fraternity. But even there, the prosecution were able to point to the observation evidence showing Mr. Pearman at Primley Park View, very close to the RS6 on the evening of the 26th of February 2008, in circumstances where it could be inferred he was checking on it. Given all this, one can certainly see a case for saying that the appellants were parties to a conspiracy to murder, whether or not they themselves variously were actually in the RS6 and actually party to the conversations recorded by the probe as summarised above. But that was not the position advanced by the prosecution at this trial. Its position throughout the trial was that the two men in the RS6 recorded by the probe in this period were Mr. Pearman and Mr. Baxter, joined on the two occasions by Mr. Slade. That was a position founded essentially on the inference. It is true that some support for such a case could be found in the evidence of Mrs. McClelland, if accepted by the jury, but as the prosecution throughout fairly and rightly accepted, such expert evidence could not, even taken at its highest, identify the men in the RS6 on those occasions as the appellants. Her evidence was, in effect, limited to saying that the voices were, in her opinion, consistent with those of Mr. Slade and Mr. Pearman, as well as Mr. Baxter, and with varying degrees of distinctiveness. On her own evidence, the voices could also be consistent with voices of men other than the appellants. The judge recorded in his written ruling that it was a central plank of the prosecution's case that the recorded voices in the RS6 were those of the appellants and crucial to proof of their case against the appellants. He said, of those proportions, they have nailed their flag to that particular mast, nor do they seek to retreat from that position. When this court studied in written submissions of the Crown, advanced at trial in response to the written submissions of no case to answer, it was not entirely obvious to us from them written submissions that the Crown indeed were nailing their flag to that particular mast, even if it certainly was part of the case then being presented and had been the basis on which the case was opened. However, Mr. Greenery told us, with commendable candour and fairness, that correctly described the position. He confirmed that it was indeed a central plank of the case being advanced at trial, and no alternative position was being advanced. The judge's description of the position thus was accurate. Accordingly, as it seems to us, as a matter of fairness, the question of whether or not the submission of no case to answer was rightly rejected by the judge has to be assessed by reference to the case then being advanced, which case included the proposition that the three voices in the RS6 were those of the appellants. That it may not, in truth, have been critical to establish a case against the appellants on that particular basis is thus, for present purposes, neither here nor there. If what was being presented to the jury by the prosecution as crucial to the proof of its case did not, on analysis, represent the conclusion properly open to the jury on the evidence, then, as we see it, the submission of no case to answer had to be decided accordingly. It thus follows that it is not for the court, in the circumstances of these particular appeals and in assessing whether or not these particular convictions were safe, to approach the matter on an alternative basis viz. That actual presence of the appellants in the RS6 on the disputed occasions was not, in truth, necessarily crucial to the prosecution's case, which was not advanced to the trial judge by the prosecution and which was not in accordance with any way the case was in fact conducted at trial. Nor did Mr. Greenery, for the purposes of the present argument, seek to contend otherwise before us. He maintained that, taking all the evidence as a whole, there was indeed evidence from which a reasonable jury could properly and safely infer that the men recorded on these occasions in the RS6 by the probe were Mr. Pearman and Mr. Baxter, and also, on 2 occasions, Mr. Slade. But we also add this: the judge's task was to assess the submission of no case to answer by reference to the arguments addressed to him and to the evidence thus deployed so far at trial. There was, in our view, no obligation on the judge to review for himself all of the evidence in order to see if there was yet any other possible arguments or evidential points available to the appellants. Even if they were not, then actually advancing them in support of the submissions of a no case to answer. We say this because, as we will come on to identify further, aspects of the submissions made to us, notably those of Mr. Vullo, undoubtedly involved an analysis of the materials and a much wider ranging factual appraisal, and in some respects deployment of factual matters not raised at trial, which went well beyond the analysis and the argument undertaken on behalf of the appellants before the trial judge on the submissions of no case to answer. We should, however, make it clear that no ground of appeal is advanced before us based on inadequate representation by trial counsel. Indeed, any such suggestion was in terms disclaimed. That said, therefore, we turn to assess whether the judge could properly conclude that there was a basis whereby a reasonable jury could properly accept what was being put forward as a central plank of the prosecution's case, and could properly reject any of the contrary conclusions. It is a reasonable starting point to note that the evidence was on any view that others also had been associated with the RS6 at this time, for example, in various of its movements and parking activities. Moreover, self-evidently, there were 4 other RS6s engaged in events outside Mr. Roberts' house on the 4th of March 2008 itself, because the appellants were themselves at the time parked nearby in an A4. No doubt it was for this reason that the conspiracy particularized on the indictment alleged of a conspiracy between the appellants and the persons unknown. On this central plank of the prosecution's case, the arguments advanced before the trial judge on behalf of the appellants, as reflected in written submissions made in particular on behalf of Mr. Baxter, which we have seen, came to this. It was said that no jury could properly or safely infer that the 2 men, or on the 2 occasions 3 men, in the RS6, as recorded variously on the probe, were the appellants. On the contrary, the evidence rebutted such an inference, or at least was consistent with contrary inference. Further, it was said that without evidence to show that Mr. Baxter, and by extension the others, was one of those recorded by the probe, the count of conspiracy to murder and the related counts must fail, as there is no other evidence. So it was asserted to show that Mr. Baxter and the others had knowledge of the recorded agreement to kill. The essential points open to be made were as follows: the analysis of the CCTV footage of 2 Sandmore Drive and its timings on the footing that it throughout was 22 minutes slower than real time was such that on the 22nd, 24th and 26th of February 2008, Mr. Baxter could not have been in the RS6 at the relevant times. Further, that potentially impacted on the alleged presence of Mr. Slade in the RS6 on the 24th and the 26th of February 2008. Linked to this point was an analysis of the mobile phone cell site tracker evidence, which indicated, so it was said, that on certain of the occasions when the appellants were, on the prosecution's case, in the RX6 having a conversation, they, or at all events Mr. Baxter, could not have been there. Thus, it was further submitted that whereas in many respects no calls were made, for the most part, between the phones of the three men when the RS6 was being operated in the relevant period, or when the Toyota Hiace was being operated on the 1st and the 3rd of March 2008. There were no such calls, the Crown said. Just because the appellants were together in the relevant vehicles, that could not be said, for example, on the 24th and 26th of February 2008, when relevant phones were, as it was said, elsewhere from the RS6 at relevant times and calls made which were not consistent with them, or at least Mr. Baxter being in the RS6 at the time. Again, linked to this point was the evidence showing text discussions between Mr. Baxter and Div, a girlfriend, in particular on the 26th of February and the 1st of March 2008. These were such that it was said he could not have been in the relevant vehicle at the relevant time, since the phone was tracked by cell site evidence to a location miles away. Further, the tone and content between the conversations was such that it was submitted it realistically could only be Mr. Baxter having a conversation with Div. It was thus fanciful to suggest, as it was submitted, that the phone had been given to someone else. The more so when there had been similar text conversations with Div on such a phone on other occasions when no alibi was needed on any view. An analysis of a computer at Mr. Baxter's home showed that on the 23rd of February 2008, the computer was used between 1912 and 1935 to access a web page entitled Cute Blonde Jaw Dropper. It was also used to watch police chases and car crashes on YouTube, but this was precisely at the time when, according to the prosecution, Mr. Baxter was with Mr. Pearman in the RS6 in the East End Park area. There was a further point available to the defence on the CCTV timings. Even if the inference was not that the CCTV timings were consistently 22 minutes slow, as they argued, then they could alternatively say that the timings, if reflected in real time, still, on occasion, were inconsistent with Mr. Baxter being in the RS6 car alleged. For example, on the 22nd of February 2008, the CCTV camera records Mr. Baxter's Mercedes ML dropping Mr. Slade off at 1954. If this was real time, then the RS6 was in the East End Park area at the time, on the tracker evidence. Again, on the 24th of February, the CCTV showed Mr. Baxter's Mercedes ML picking up Mr. Slade at 2 Sandmore Drive between 1802 and 1805, when the RS6 is shown on the tracker as being on the A64 in Leeds, a considerable distance away. A similar point arises for the 26th of February 2008. Thus, overall, an inconsistency with the prosecution's case could be said to arise whether the CCTV was consistently 22 minutes slow before the 4th of March 2008. The CCTV was consistently showing real time. Furthermore, if all these points were valid, they would operate to show that no further support could be derived from Mrs. McClelland's voice recognition evidence. As we have said, it was accepted that if the voice recognition expert evidence was controverted by other evidence, it would yield to that evidence. And further, Mrs. McClelland had herself stated the view that the voices were, in her view, the same throughout, and if she was wrong in one instance with regard to the particular male, then she could not be taken as right in the other instances in regard to that male. The judge rejected the arguments advanced to him, preferring the arguments of the prosecution. As to the point about the CCTV timings in this period, he said, the argument rests on the premise that the CCTV time can be relied upon. It cannot. The only fact that is sure is that following seizure of the CCTV time, it was 23 minutes slow. Therefore, another triable issue is raised retiming on earlier dates. As to the point that the mobile phone cell site analysis showed, for example, relevant phones to be elsewhere at the time of some of the recorded RS6 conversations, taken with the related point concerning the div text from the phone attributed to Mr. Baxter. He describes these points as superficially attractive, but he considered that an explanation could be found in the evidence that the cell site analysis could only show the location of the phone in question. It could not show in whose hands the phone actually was at any given time. He coupled that with the reference to the prosecution point that, as evidenced by the appellant's searches on computers concerning jamming, the removal of batteries from their phones on the 4th of March 2008, and so on, the appellants could be taken as cell site savvy, thus consistent with the phones having been placed in other hands at relevant times. There thus was raised a triable issue as to whether the defendants were in the RS6 at these times. As to the access to Mr. Baxter's computer on the 23rd of February 2008, the judge considered, in the absence of any explanation from Mr. Baxter that could be explicable by reason of, say, a teenager within the house, he reviewed at length all other points raised, and concluded that the submission should be rejected. The appellants submit that the judge was not justified in rejecting the submissions of no case to answer, as he did, and submitted that the central plank of the prosecution's case, as showing the appellants being party to a conspiracy to murder, was indeed not capable of being sufficiently proved. No inference to the exclusion of other inferences could properly be drawn as argued for by the prosecution. In particular, they criticise as wholly inadequate the prosecution's statement to the judge that the CCTV times may or may not correspond with the time shown on the 4th of March, and the judge's approach to the CCTV timing they submitted was tantamount to reversing the burden of proof. Overall, the case should have been withdrawn from the jury, given that the way the prosecution had sought to advance it in trial. We have considered these various points with care. There is no doubt that they are powerful points, and they merited close consideration by the judge himself. In this regard, however, it is necessary to bear in mind that the judge was plainly wholly on top of the evidence as it had emerged during the prosecution's case, which perhaps in part explains the relatively shorthand way in which the appellant's written submissions were presented at trial. It is at all events evident from his full ruling, which ran to 34 paragraphs, that he had careful regard to all the submissions made to him. We also bear in mind that Galbraith itself makes clear that matters close to the line of submission of no case to answer can safely be left to the discretion of the judge. We have concluded, assessing matters as best we can on the basis of the arguments and materials we now understand to have been put before the judge, that we should not interfere with his ruling. As the judge said, on the evidence adduced at the trial, the only sure fact with regard to the CCTV timings was that on the 4th of March 2008, it was some 22 minutes slow compared to real time. It did not follow as an inference that it must likewise have been 22 minutes slow on each day in the intervening periods between the 21st of February 2008, nor did it follow that it showed the real time on those days earlier. As the jury had heard and could conclude, the appellants were surveillance savvy, and one question the jury could not properly ask themselves in the absence of explanation was as to how and why the CCTV timing at Mr. Slade's house came to be out by 22 minutes on the 4th of March 2008. Further, there had been evidence at trial from the police by DC Leon that when examined in May 2008, the date on the CCTV was then weeks out and the time 13 minutes out, and the jury had no expert evidence of the kind sought to be deployed before us on this appeal by the appellants, as we mention later on, to provide an explanation for that, with the view of showing consistency of the CCTV timings in the indictment period. Similar considerations, in particular by reference to the appellant's surveillance and mobile phones savviness, could be applied to the apparent alibis arising from relevant mobile phones being on occasion elsewhere from the RS6 at the time of some of the critical instances relied upon by the prosecution. When these points are set out in context of all of the many other factors accumulating lending powerful support to the Crown's case, that the appellants were party to a conspiracy to murder Mr. Roberts as set out by the judge, our view on balance is that the judge was entitled to rule as he did. This ground as formulated in this way thus fails, but we have also concluded that cannot, given the circumstances of this particular case, be the end of the matter. What this court ultimately had to consider, after all, is whether these convictions are safe, and we are simply not able to put out of our consideration the impressively powerful presentation by Mr. Vullo, based on the meticulously prepared schedules put before us, correlating the relevant CCTV sightings at 2 Sandmore Drive with the mobile phone cell site evidence and the tracker observation evidence, which we will come to summarise. We have nevertheless deliberated as to whether it is right for us to entertain these points as advanced by Mr. Vullo at all. To a significant extent, the points now advanced to us do make, albeit with much more elaboration, points sought to be advanced to the trial judge on submissions of no case to answer, but also go very much further. For one thing, they focus on the CCTV timings, both on the basis that they were 22 minutes slow throughout, and on the alternative basis that they showed a real time throughout, with a view to positively demonstrating that the CCTV clock was indeed consistently 22 minutes out on each day in the alleged conspiracy period. This was done in much more detail that was advanced to the trial judge, where the defence stance had been confined in effect to arguing for the inference as to the CCTV timings. Further, this exercise was also conducted before us in relation to days, not simply the 22nd, the 24th and the 26th of February 2008, other than those on which the judge had been addressed. This was with a view to, as Mr. Vullo explained, showing a consistent pattern throughout this period as to the CCTV timings, a potentially very important point. A yet further development was deployed by Mr. Vullo, and in one instance Mr. Vaughan, of telling materials which, although based on evidence available at trial, do not appear to have been advanced in evidence or argument before the judge. Does then the importance of the one trial principle that the defence should present the best case available to it at trial preclude to having regard to these matters, be they styled fresh arguments or fresh evidence, albeit the evidence on which the arguments to us are based was not fresh, in the sense that it was evidence available at trial, even if not deployed by the defence for these purposes. We have come to the conclusion, however, that as a matter of justice and in the circumstances of this particular case, we should not regard ourselves as so precluded, and that we should have regard to these matters as advanced by Mr. Vullo. Quite simply, the detailed analysis presented to us, coupled with the deployment of the new evidential points not advanced at trial, has persuaded us that the CCTV timing has positively been demonstrated to be some 22 minutes out on each day in the period. The judge's who knows position with regards to the CCTV times taken at the stage of submissions of no case to answer, and then as put to the jury in summing up, has now been shown to have been wrong. When one links that now demonstrated fact, the other arguments that were and remain available, the alibi evidence of the phones, the div text, the accessing of Mr. Baxter's computer at his house on the 25th of February 2008, and as further confirmed by other points advanced to us. In our view, it is established that the central plank of the Crown's case, as advanced in trial, was one that was not available. On all the evidence now before this court, it could not and cannot be proved by the prosecution that Mr. Baxter, if not also the other appellants, variously were in the RS6 discussing the killing of Mr. Roberts, as relied on in the trial. In such circumstances, we have considered it right, in the interest of justice, to receive these matters as advanced to us. If one takes into account the fact that, in due course, the jury were, albeit understandably at the time, directed in the summing up, consistently with the prosecution's case as advanced at trial, that it was open to them to conclude the appellants had been the men recorded on the various occasions in the RS6, and to reject the defence alibi arguments, then the conclusion simply has to be that the convictions are not safe, for that central plank as advanced by the Crown to the jury has been removed. Indeed, that aspect of the Crown's case may, adversely to the appellants, have potentially achieved still greater prominence in the minds of the jury by that stage, given that the prosecution and judges' understandable repeated emphasis on the fact that none of the appellants had given any evidence, or for the most part, answers in interview to provide any explanations. We turn to summarise the points advanced before us by Mr. Vullo by reference to his schedules to explain our conclusion in a little more detail. The main focus of the schedules and arguments before us was directed at the movements of Mr. Baxter, but this in turn potentially may impact the position of Mr. Slade, outside whose house Mr. Baxter's Mercedes ML is on occasion recorded as arriving or leaving, as the case may be. The position of Mr. Pearman in turn again may be rather different. But Mr. Greenery pragmatically did not seek to argue before us that there could be one outcome for this appeal for one or more of the appellants, but a different outcome for the other appellants. We would pay tribute to the meticulous attention to detail which underpinned Mr. Vullo's compelling analysis, and the schedules prepared to support it, and to the skill and care in which he presented it. The schedule deploys before us are essentially, as we gather, all founded on materials available for use at trial. They relate to each day from the 22nd of February to the 4th of March 2008. They are compiled in the following way. Each schedule sets out for the day in question the details and times recorded on the CCTV at 2 Sandmore Drive. Each schedule by way of table then identifies from the telephone records in the evidence at trial any calls made by one or other of the two relevant mobile phones attributed to Mr. Baxter at the time, as actually shown on the CCTV of the attendance of Mr. Baxter in the Mercedes ML at 2 Sandmore Drive. Where there is such a call, there is identified the time the call starts, the cell sites used by that mobile phone to access the network, the end of the call and the duration of the call. The cell sites are plotted on a map so that one can identify the location of the cell sites being accessed. Where a particular cell site has been identified as the best server site for 2 Sandmore Drive, that has also been identified. Each schedule then sets out a second table constructed on the assumption that the CCTV footage timing was running 22 minutes slow on each day. On that assumed basis, times are accordingly attributed to events shown as recorded on the CCTV, which are 22 minutes later than those shown on the first table in the schedule. The table then shows by reference to the cell site and the mobile phone records whether the phones attributed to Mr. Baxter were sending or receiving, at the time adjusted by 22 minutes, messages of the type contained in the table with the unadjusted times. Further, on each schedule there is a map showing the plotted and timed positions of the RS6 on each such day, identified either by tracking devices or actual police observation. Finally, there is a table showing times of conversations within the RS6 as recorded by the probe. By this process, and by cross-referencing events recorded on the CCTV at 2 Sandmore Drive at the adjusted times with the cell site mobile phone material, identifying contact by or to phones attributed to Mr. Baxter, there is scarcely any reconciliation on any of the days between the CCTV images showing Mr. Baxter's ML outside or near to 2 Sandmore Drive and the cell sites accessed by the phones attributable to him. By way of contrast, if one then undertakes the same exercise adjusting the CCTV timings by 22 minutes, then the telephone usage relating to Mr. Baxter's phones on each day closely ties in with the events recorded on the CCTV footage. Those phones are, at such adjusted times, then accessing cell sites which are either best server sites for 2 Sandmore Drive or very close to it. Further and more importantly, the pattern is repeated on each day throughout the period, including the 4th of March 2008, when the Crown itself accepted that the CCTV clock timings were 22 minutes out. This had particular importance, as Mr. Vullo observed, because it went beyond the point of relating to phones allegedly providing an alibi on the 24th and 26th of February 2008. In such circumstances, the appellants contend that there is clear evidence compelling a conclusion that the CCTV timings were indeed 22 minutes out on each day during the entire period of the alleged conspiracy. The CCTV timings therefore were neither operated at times they showed as real time, nor were they operating on a persistently erratic basis. A further schedule provided by Mr. Vullo seeks to confirm the point by different means. 2 regular events in the daily routine at 2 Sandmore Drive, as caught on CCTV, are taken. These are the morning school run and the arrival of the cleaner on weekdays. Throughout, there is a broad consistency in these timings. This is accordingly both indicative of there being no deliberate change in the timings of the CCTV recordings, and also indicative of the timing mechanism operated consistently in this period. Yet further, a series of stills taken from the CCTV on the 22nd and 27th of February and the 1st of March 2008 were provided to us. These appear to show Mr. Slade, or once Mr. Baxter, using a mobile phone at or outside 2 Sandmore Drive. The timings of these events, as shown on the CCTV footage, do not match up with the use of the mobile phones attributed to Mr. Slade or Mr. Baxter, but when adjusted by 22 minutes, they do. We thus have concluded that these schedules demonstrated, to our way of thinking, that the internal clock on the CCTV was indeed running consistently some 22 minutes slow on each day throughout the period of the alleged conspiracy. The resulting position can be assessed by taking as examples on the days the 22nd, the 24th and the 26th of February, as detailed on the schedules, on the footing that the CCTV clock was indeed 22 minutes slow. Then on the 22nd of February 2008, the position becomes as follows. At 2014, the RS6 is tracked down at a location near Red Hall Approach, the time at which the probe is recording a conversation in the RS6 to which the prosecution case Mr. Baxter was a party. However, at 2015, on the adjusted CCTV timings, Mr. Baxter's Mercedes ML is shown on the CCTV arriving outside 2 Sandmore Drive, and at 2018, a mobile phone attributed to Mr. Baxter started a call lasting 1 minute 39 seconds, accessing the best serving cell site for 2 Sandmore Drive. Red Hall Approach, as was agreed, is some 6.8 kilometers distance from 2 Sandmore Drive. The Crown's case, we repeat, as Mr. Greenery confirmed, was that it was Mr. Baxter and no one else who always drove the Mercedes ML. On the 24th of February 2008, the position becomes as follows. Between 1825 and 1833, the RS6 is tracked at or near the A64 York Road at a time when Mr. Baxter is, on the Crown's case, a participant in a conversation in a car recorded by the probe. By 1824 and 1829, as shown on the CCTV, with the adjusted time, Mr. Baxter's Mercedes ML arrives at and then leaves 2 Sandmore Drive. The mobile phone cell site records showed 2 phone calls being made from a mobile attributed to Mr. Baxter at 1829 and at 1830, on each occasion accessing the best serving cell site for 2 Sandmore Drive. The A64 York Road is in the East End Park area, on the other side of Leeds from Sandmore Drive. On the 26th of February 2008, the position becomes as follows. Between 1845 and 1856, the RS6 is tracked in the vicinity of the A64 York Road, at a time when the probe is recording a conversation in the RS6 in which, on the Crown's case, Mr. Baxter and Mr. Slade are participating. At 1849, however, as shown on the CCTV, with the adjusted time, Mr. Baxter's Mercedes ML is outside 2 Sandmore Drive, leaving at 1852. At 1849, a phone attributed to Mr. Baxter, lasting 1 minute 37 seconds, is made accessing the best serving cell site for 2 Sandmore Drive. We repeat that there is no difference in pattern between the various days in the entirety of this period, including the 4th of March 2008. Yet further, this material was, as Mr. Vullo submitted, to be put in context both of the alibi phone occasions and also of the text from Mr. Baxter's relevant mobile phone to that of Div. On this last point he relied, as had been on behalf of Mr. Baxter at trial, in particular on these entries relating to the 26th of February 2008, which showed a series of exchanges between 1804 and 1938, when the RS6 was in use. But when the relevant phone was in the location elsewhere than at the location of the RS6, being at or near to Sandmore Drive, as well as such the div text on other dates. In this regard, he was also entitled to reiterate the point which had been made at trial, that the highly personal nature of such text is not readily consistent with anyone other than being Mr. Baxter being the user. Moreover, Mr. Vullow's argument derived support from yet another point. There were available at trial records of automated number plate recognition sightings. Mr. Vaughan, on behalf of Mr. Baxter, submitted that from those, it was demonstrated that on the 24th of February 2008 at 2041, at a time when the RS6 was tracked to the East End Park area, Mr. Baxter's Mercedes ML was in fact identified at a location in Leeds over 5 miles away. This too is evidence of a kind which is available at trial but was not used, perhaps because it was overlooked. But it lends further support to Mr. Vullow's points if further support is needed. Overall, Mr. Greenery had the greatest difficulty in formulating submissions to controvert these points made by Mr. Vullow and as adopted by all counsel for the appellants. In our view, as will be gathered, they will not be controverted. We think it appropriate to deal nevertheless with the other grounds advanced. The summing up of the judge was lengthy and detailed. It was clearly structured. It dealt fully with the evidence and the outlined issues. It was a very long way indeed from being a summing up of the kind involving reading out vertebrim, the notes from the judge's notebook or anything like that. At trial, counsel for the appellants nevertheless made objections on the record at the conclusion of the summing up as to its fairness and balance. That objection is maintained before us. We were taken into considerable detail through a number of the passages in summing up. It was complained that in many places it read like a speech for the prosecution. It was said that the judge persistently in the course of the summing up adopted a technique not only of emphasizing and commending the prosecution points, but also when dealing with the defense points designed to refute prosecution points, Ben himself making comments designed to depreciate those defense points, and further did so when summarising the defence case at the end of summing up. Moreover, he did so, it is said, in trenchant and dismissive terms. It is further complained that the judge dealt with the points strongly relied upon by the defence, the CCTV timings, the alibi phone calls, and so on, in a cursory and dismissive way. It was further observed that, towards the end of summing up, the judge twice said that he was not seeking to undermine the defence's case. A coded acknowledgement, it was suggested, of an appreciation that that is precisely how it may otherwise have been viewed. Particular illustration, it was said, of the unfair comments made, amongst others, can be taken from a passage of the summing up relating to the fact there had been no actual observations made by the police of any of the three appellants being in the RS6 during the days of the alleged conspiracy between the 21st of February and the 4th of March 2008. The judge, as to that, commented, obviously it is an admission in the investigations and observations that the police were doing, and no doubt somebody will be wishing that a camera had been set up long before it was to monitor comings and goings. It is complained that that conveys the inference that had only such observations been made, further incriminating evidence would have emerged. Numerous other passages were also relied upon to similar purport. Given our overall conclusion, we can take these submissions shortly. The judge was here dealing with a highly tactical defence case, where all the indications are that leading counsel for the appellants at trial had perhaps taken the limit what might properly be advanced in closing speeches in the absence of any answers in interviews. Any defence case statements or any evidence at trial from the appellants themselves, and when the prosecution had by then, of course, made its own closing speech and had no further right of response. The judge had to deal with that situation arising. We can accept that some of the passages in the summing up might be in places have been better framed or balanced, or have been put in a somewhat different language. But overall, we are not persuaded that this summing up was unfair or unbalanced to such an extent as to render the convictions unsafe. This ground fails accordingly. Our ultimate conclusion also means that it is strictly unnecessary to deal with the applications formally to adduce fresh evidence, but we think it appropriate to do so. This is not only out of defence to detail of the evidence in which the first instance received by us, and to the careful arguments presented to us on it. It is also because our views may perhaps in some respects be of relevance for wider purposes. The proposed fresh evidence was in each instance expert evidence. The evidence was, as we have indicated, directed at two distinct areas. First, relating to the timings of the internal clock relating to the CCTV system at Mr. Slade's residence at 2 Sandmore Drive. Second, relating to voice recognition. The statutory criteria for admitting fresh evidence are, of course, those set out in S23 of the Criminal Appeal Act of 1968. Ultimately, the court has to consider whether or not it is necessary or expedient of these interests of justice for such evidence to be received. The court is required for this purpose to have regard in particular to matters set out in S23 2 A, B, C and D. For the purpose of exercising its statutory jurisdiction, the court has to balance two competing principles. The first, to which we have previously alluded, is that the incumbent on the defence to present his whole case at trial, the one trial principle. It is, in general terms, contrary to the proper administration of justice for a defendant to advance on appeal a case different from or other than the case he is able to present at trial. The second, however, is that it is generally abhorrent to the proper administration of justice that the defendant may have been wrongfully convicted. The court also has to weigh these matters and all other relevant matters, including those specified in S23 2 A to D, in deciding whether or not to receive the proposed fresh evidence. At all events, the impression sometimes is that given the appellants, and on occasions perhaps, was sometimes given in arguments advanced before us on behalf of the appellants in this case, that if only the fresh evidence may afford a ground for allowing an appeal, then that of itself justifies its reception into evidence. But demonstrably, the consideration has to be wider than that, the ultimate question being whether it is necessary or expedient in the interest of justice to receive the evidence. In the context of the proposed reception of fresh expert evidence, we were referred to a number of authorities. These included, with a helpful summary given by Atkins L.J. in Chatu 2012 at paragraph 70 of the judgment. See also Workman 2014 at paragraphs 59 to 63 of the judgment. The observations of the court in those cases, as was not disputed before us, provide a convenient summary of the required approach. Mr. Owen sought to place particular emphasis on the decision of the Privy Council in the case of Lundy 2013. That was a New Zealand case, whereby the underlying principles are broadly comparable to, if not identical to, those set out in S23 of the 1968 Act. It was a striking case in that expert evidence was, in the circumstances of that case, permitted to be received in evidence by the Privy Council, even though its availability had been, for the most part, been known to counsel at trial. Mr. Owen referred in particular to the observations of Lord Kerr at paragraph 120 of his judgment, and to his observations in paragraph 128 that, where the new evidence presents a direct and plausible challenge to one of the central elements of the prosecution's case, this factor, the one trial principle, ceases to be of such importance. Ultimately, however, as we see it, just where the balance lies in assessing what is necessary or expedient in the interest of justice has to be decided by reference to the particular circumstances of each case. And in this regard, as emphasised in Chatu in paragraph 70, the appellate court must, amongst other things, be careful not to allow the trial process unjustifiably to be subverted. The appellant sought to advance as fresh evidence an expert report dated the 28th of July 2014 from Mr. Subdeep Joseph Abraham, a computer crime consultant working with Systems Technology Consultants Limited, SITEC. Mr. Abraham's expertise was not in dispute. He was demonstrably a credible and reliable witness. Mr. Abraham had, in 2014, been asked to perform tests on the CCTV system which had been seized from 2 Sandmore Drive on the 4th of March 2008. It will be recalled that the evidence given at trial was that the entire trial was conducted on the basis that, as at that date, the 4th of March 2008, the CCTV time clock was some 22 minutes slow compared to real time. The tests Mr. Abraham was asked to perform were undertaken with the view to showing that the clock had been similarly slow, that is 22 minutes slow, in the days and weeks before the 4th of March 2008. If that was so, then that, as will be gathered, undetermined the prosecution's case of Mr. Baxter and or Mr. Slade's presence in the RS6 as recorded and corroborated the alibi's arguments advanced by the defence. Thus, this expert evidence was designed in this respect to show what Mr. Vullo had set out to show by reference to his schedules. Mr. Abraham received the CCTV system from West Yorkshire Police on the 23rd of June 2014. The system was then checked to see if it was working properly when powered by main electricity, and it was synchronised. Thereafter, it was run from the period between the 16th of July and the 28th of July 2014. It was then assessed for time differentiation and was found to have lost 2 seconds in that 12-day period. Mr. Abraham's calculation was, on that basis, it would take about a year for the CCTV clock to lose 1 minute. He further reported on the pronounced time variations identified on the CCTV system was examined by police in May 2008 as compared to the 4th of March 2008, to the effect that on the 28th of May 2008, the date on the CCTV system when then examined was some 7 weeks out and the time 13 minutes out, as was explained in evidence given at trial by DC Leon. Mr. Abraham said that was to be explained by the CCTV system having been entirely switched off in the interim and the battery's power in consequence having becoming degraded. He did however agree in cross-examination before us that something must have happened to cause the clock to be 22 minutes late on the 4th of March 2008. For example, as one possibility, interference by the user. The appellants therefore say that Mr. Abraham's evidence is very important evidence. If, as was the unchallenged evidence, the CCTV clock was indeed out by some 22 minutes on the 4th of March 2008, then the evidence of Mr. Abraham goes positively to confirm the defence's case at trial that it would indeed likewise have been out by some 22 minutes in the preceding weeks and days. And if that was so, then such timings, by reference in particular to the CCTV showing Mr. Baxter in his Mercedes ML variously picking up or dropping off Mr. Slade at 2 Sandmore Drive, demonstrated the defense point that Mr. Baxter and or Mr. Slade simply could not have been in the RS6 on various of the occasions relied upon by the prosecution at trial. That, of course, was precisely the point Mr. Vullo was seeking to make. It is, as we have said, the case that, at trial, the defence has understandably been seeking to make much of the arguments that the CCTV time was, as accepted, some 22 minutes out on the 4th of March 2008, and therefore, so they argued, similarly out as a matter of inference in the preceding 2 weeks. Equally, it is clear that the Crown had not accepted that later point. It is however known that the trial defence team on behalf of Mr. Slade in fact had, at the time of trial, already commissioned a report from SITEC that was provided by Mr. Darren Greener and was dated the 4th of June 2009. Mr. Greener, who still works for SITEC, also gave evidence before us, which there is no reason to doubt. Mr. Greener in his trial report had, amongst other things, considered the date and time accuracy of the CCTV system retrieved from 2 Sandmore Drive. He said they were only as accurate as the setting applied. He was critical of the police's storage and handling of the system after the seizure. He also noted that at the time of his initial report, the footage from the CCTV system for the relevant period had not been reviewed by SITEC. He suggested further review. This, however, was something he and his team only undertook as we were told after trial. The consequence of that subsequent review was that 2 breaks in the continuity were noted for on the 1st of February 2008, something Mr. Greener attributed to the overwriting of the footage, since the recording runs continuously and after a period of time of new material overwrites and obliterates early material on, as it were, a first in, first out basis. No other breaks in continuity, however, were noted by him or his team in the period of the 1st of February 2008 to the 4th of March 2008. Mr. Greener had been asked to attend the trial. He told us that there was a conference at court with the defence legal team, which included discussion of the 22-minute point, and in the event he was not required to give evidence. In such circumstances, we are not prepared formally to admit the evidence of Mr. Abraham. The defence were alive at trial to the potential importance of the 22-minute point and the CCTV footage, and Mr. Slade had commissioned a report from Mr. Greener at the time for that purpose. Mr. Greener had not been instructed at the time to make further investigations to which he alluded, nor had he been asked to give evidence at trial. The evidence thus was, or reasonably could have been, available. It was submitted to us that the defence could have properly taken it, and it was said that Mr. Slade's trial counsel did take it, that the Crown was not disputing that the CCTV time was around 22 minutes out throughout the relevant period, but the Crown clearly had not accepted that as a fact. Further, one can envisage that the defence tactically might prefer to make their points, as they did, by reference to inferences which they asserted might be drawn, rather than, for example, exposing Mr. Greener to the possibility of a cross-examination. For example, as to how the CCTV came to be out by 22 minutes on the 4th of March 2008, with a potential suggestion that Mr. Slade, as an end user, and against the background evidence that the appellants were surveillance savvy, could have reprogrammed the clock on each day accordingly. In our view, therefore, it is not necessary or expedient in the interest of justice that Mr. Abraham's evidence be received. This was evidence of a kind available to the defence at the trial, which it elected not to explore further or deploy. In any event, the point sought to be made is now covered by Mr. Vullo's analysis. Indeed, Mr. Owen himself accepts in his written argument that the new Cytex evidence merely confirms the point now being made as to the CCTV timings. We accordingly formally refused the application to receive this evidence from Mr. Abraham. This ground raises issue altogether more complex than the application to reduce the Cytex evidence. It was, and will be gathered, the prosecution's case that men recorded speaking in the car on various occasions were the appellants. In support of that allegation, which is strongly disputed by the appellants, the prosecution, as we have said, adduced expert evidence of Mrs. Cleland as to the voice identification. Expert evidence of this nature commonly involves a comparison of the question sample of recorded speech with recording of a person alleged to be involved in the crime, with a reference sample comprising a recording of what is known to be the voice of the suspect. From that comparison, the expert witness forms an opinion as to how far the two recordings are consistent with having originated from the same speaker. The usual methods of comparison are auditory analysis and acoustic analysis. The former usually involves expert witnesses repeatedly listening to the recording through high-powered headphones and making a judgment. The latter involves the application of computer software to make a computerized analysis, which may include spectrograms of specific sounds and formant measurements, that is, computerized measurement of resonance or areas of high energy in the recorded speech. Mrs. Cleland's methodology used only auditory analysis. She was skeptical about autistic analysis generally, one of her reasons being that she did not believe there would be a sufficient database to enable the expert to know what could be expected of the population as a whole, and therefore was nothing with which reliably to compare the findings in the particular case. She also took the view that formant measurements could not be reliably used and could be misleading when recording concerns had not been made in clear conditions free of interference. She acknowledged that, in this respect, she is, in a minority amongst practitioners in the field. The majority use a combination of auditory and acoustic analysis. In Rob 1991, this court held that expert evidence of voice identification based on auditory analysis alone is admissible. In 2002, the Court of Appeal in Northern Ireland took the view that time had moved since the decision of Rob and concluded that jurisdiction, no prosecution should be brought in which one of the planks was voice identification based on auditory analysis alone. See O'Doherty 2003. In England and Wales, however, there has been no similar developments in the law, and in Flynn and St John 2008, a constitution of this court declined to follow the decision of O'Doherty. See in particular paragraph 62 of the judgment of the court given by Gage LJ. Miss Cleland had been provided with copies of some of the recordings made in the RS6, in which the male voices were designated M1, M2, etc. These recordings carried engine traffic and other noises, as well as voices of the speakers. She had also been provided with reference samples of the speech of each of the appellants. Some of these came from police interviews, but reference samples of voices of Mr. Baxter and Mr. Slade also included a recording, Exhibit Holdall 12, which was admitted to be of them speaking in a different vehicle, a Peugeot car. The reference samples of Mr. Pearman included a recording, Holdall 42, of him speaking in a third vehicle, the BMW car. The recordings in the Peugeot and the BMW had been made covertly, and they too carried engine noise and traffic noise. In relation to the voices of the men speaking in the RS6, Mrs. Cleland was asked to consider whether each of the voices designated as M1, M2 and M3 was the same voice in each recording in which it was thought to be heard. She was also asked to consider whether the reference samples of the appellants were phonetically and linguistically consistent with the questioned voices. Mrs. Cleland explained to the jury that forensic voice analysis first entailed forming an opinion as to whether the question and reference samples were consistent with the speech having originated from the same person. If so, it then entailed going on to express how closely matched samples were, using a 5-point scale of distinctiveness, ranging from not distinctive to exceptionally distinctive. The distinctiveness scale enabled the expert to consider detailed phonetic and acoustic features over and above the broad consistency which had first been noted. This involved considering, by an intensive listening over many hours, the fine detail of articulation of vowel and consonant sounds, rhythm, pitch, intonation and voice quality, timbre, and making on scale how many of these features and to what extent were judged to be distinctively similar across the reference and question samples. As we have said, it was never the prosecution's case that voice identification evidence alone could prove that a particular appellant was a particular speaker in the RS6. The evidence was put forward only as one aspect of the prosecution case. Mrs. Cleland also made clear at an earlier stage of her evidence in chief that forensic voice analysis could only operate as a freestanding identification of an individual. She said, "It is important to recognize that forensic voice analysis isn't equivalent in any sense to identification evidence form, for instance, DNA or fingerprinting. The conclusions we can reach in terms of voice identification should only be used in conjunction with other evidence as part of the picture. You can't identify an individual solely by using an opinion from a forensic voice analysis." Mrs. Cleland's evidence was that the designation of M1, M2 and M3 was consistent across all the question samples recorded in the RS6. In some of the recordings, the level of background noise was such that she could not form any view about the degree of distinctiveness. Other sections of the recordings were clearer and enabled her to express an opinion of the distinctiveness scale. Her findings in summary were as follows. She found the voice of Mr. Pearman to be consistent with the voice of M1, and in some passages of the recording she assessed it moderately distinctive or distinctive. She also, it may be observed, identified Mr. Pearman's voice with low-level consistency from a brief passage recorded in the RS6 on the 4th of March. but the prosecution accepted that Mr. Pearman was not in the car on that day. She found the voice of Mr. Baxter to be consistent with the voice of M2, and in some passages of the recording she assessed it to be moderately distinctive. She found the voice of Mr. Slade to be consistent with the voice of M3. In relation to one passage, she assessed it as moderately distinctive. In relation to another passage, she initially said that there was a low level of distinctiveness. She then, in cross-examination, withdrew her attribution of that passage on the basis that similarities were at such low level that no identification was possible. However, in re-examination, she said that when she made that assertion, she had not been well and was not thinking clearly, and she repeated that there was low-level consistency between the known and questioned voice of Mr. Slade. On behalf of Mr. Pearman, Professor French gave evidence at trial. He has worked in this field for some 25 years and has given expert evidence in many cases. He is an honorary professor in the Department of Language and Linguistic Science in the University of York and the president of the International Association for Forensic Phonetics and Acoustics. His work in this case has been peer-reviewed by his colleagues, Dr. Fawkes, who also gave evidence at the trial. Professor French had used a combination of auditory and acoustic analysis. He regarded Miss Cleland's approach of using auditory analysis alone as no longer acceptable practice. He disagreed with Mrs. Cleland's evidence relating to Mr. Pearman. When he first prepared a report in this case, he found consistency between Mr. Pearman's voice and the voice of M1. However, he subsequently analysed the Holdall 42 recording from the BMW and concluded on the basis of voice quality and phonetic differences, which he explained to the jury, that there was no consistency and that it was very unlikely that Mr. Pearman was the speaker in the RS6. He did not feel able to eliminate him completely. He said that there was a remote possibility that M1 was Mr. Pearman. Neither of the other appellants called any expert evidence on this topic, as we have explained, although the jury were made aware that Mr. Duckworth had been instructed on the behalf of Mr. Slade and Dr. Holmes on behalf of Mr. Baxter. The jury were also made aware that Mr. Duckworth agreed with Mrs. Cleland's attribution of M3 to Mr. Slade in a recording on the 26th of February as moderately distinctive. Dr. Holmes accepted that Mr. Baxter's voice was consistent, but no more than consistent with M2. The judge, in his summing up, gave an appropriate direction to the jury about their approach to this evidence, explaining to them that although they had heard the recordings for themselves, the expert witnesses had the advantage, which the jury could not have, of repeated listening to the recordings on specialised audio equipment. After the trial, Professor French and his colleague Mr. Harrison were instructed to conduct further voice comparisons using automatic speaker recognition (ASR) technology in the form of a system known as BATFOX. Initially, they did their work solely in relation to the appellant Mr. Pearman, but they were later instructed also to consider recorded voices said to be those of the other appellants. In their first report on the 1st of June 2012, dealing with Mr. Pearman alone, they concluded that the results of the BATFOX tests were 37 or 38 times more likely if M1 was not Mr. Pearman than if was. A new version of the BATFOX system then became available. This was used in carrying out tests in relation to all three appellants, in the course of which the Holdall 12 recordings from the Peugeot car were used as an additional reference sample. The overall result of their work in relation to Mr. Pearman and Mr. Slade was summarised as followed in their report on the 17th of July 2014. In our view, the voice evidence in respect to these two appellants provides exceptionally strong support for the defence's claim. We consider that Richard Pearman and Dennis Slade can be eliminated with an extremely high degree of confidence. This is effectively a categorical statement of elimination. As to Mr. Baxter, Professor French and Mr. Harrison concluded that he could be eliminated with a fairly high degree of confidence. All three appellants have sought to adduce this evidence as fresh evidence. This court heard the Ben S. evidence from Professor French and Mr. Harrison, as well as evidence from Mr. Alan Reson, who was called by the respondent. In their submissions as to the considerations which were relevant for the purposes of this Section 23 application, the parties focused on two issues. Was Professor French able at trial to give evidence based on the ASR technology, and was it necessary or expedient for this court to receive the evidence? In their report on the 1st of June 2012, Professor French and Mr. Harrison explained that the ASR systems work on the principle that the individual voices may be distinguished from one another by virtue of vocal tracts, or from which they emanate having different anatomical dimensions or proportions. These differences give rise to acoustic differences, namely differences in the structure of resonance of frequencies found across the speech of individuals. ASR systems take the recorded voices of individuals, perform complex mathematical operations on them, and reduce them into statistical models. A statistical model is then made of the known sample and the question sample, and the two are compared to produce a measure of similarity or difference between them, in order to determine whether the measure is indicative of having come from the same or different speakers. The extracted features are also compared with a set of statistical models from a reference population of other speakers held within the system. Characteristics of the reference population, including gender, language, and recording conditions, should ideally be at the same of those of the suspect recording. The measure of difference or similarity between the compared recordings is expressed by the ASR system and as a likelihood ratio. That is, an expression of the ratio of how likely it is to have been found the voice evidence if the samples were to have come from the same speaker, against the likelihood of having found the evidence if they had come from a different person. A likelihood ratio of more than 1 means that the evidence would be more likely to occur if the speaker were the same. A likelihood ratio of less than 1 means that the evidence will more likely occur if they had come from different speakers. Professor French said in evidence that he first acquired Batvox in March or April 2009 and trialed it in July-August that year. He therefore had access to the Batvox system at the time of trial of these appellants. However, he took the view that at the stage it had not had sufficient testings with samples of English voices for him to use it in his forensic work. He said that his subsequent testings included tests which showed the Batvox system to be sensitive of regional accents, but without large differences, and further testing in circumstances in which the quality of the sample recording was less clear. The results of those tests and testings of the systems by others led him to regard it as a system which could be used in casework by the end of 2010, the start of 2011. He has not, however, used the system in any of his forensic work other than this case. In their evidence to this court, Professor French and Mr. Harrison explained that the Batvox software which they had used had a database or reference population of 100 male speakers of standard Southern British English, aged 18 to 25, who had been recorded in the form of stimulated police interviews. From that population, the software automatically chose a smaller subset on the basis of their statistical models matching most closely that of the suspect. The subset could be as low as 20, but they had set the system so that a subset of 35 was used. It was not altogether clear from their evidence which 35 sample voices the system chose for comparison with each of the appellants, nor why the figure of 35 was selected. Insofar as the subsets may have differed from one another, at all events, the court has no information as to what the differences were. At trial, it was common ground between Mrs. Cleland and Professor French that voice quality timbre is an important marker of a voice. Professor French told this court that he and his colleague had initially considered that ideally the reference sample should comprise speakers who came, like the appellants, from West Yorkshire, but ultimately they had decided that it was not necessary because the system considered the reference population appropriate for the tasks. Mr. Harrison explained that the software's reference population of 100 is not to be thought of in the same way as the database used for DNA analysis. He said that the purpose of the reference sample is to assess how usual or unusual a feature of speech is, and so to show whether the score is what one would expect as between the questioned and the reference samples. He said that there is no regional variation in vocal tracks, and therefore it was not particularly important to know where the person in reference sample came from. He also said that their work had been peer reviewed and there had been no criticism of the size of reference population. Professor French and his colleague had reported that when 27 different voices were compared with the known voices in the B&W and Peugeot recordings, the system showed a likelihood ratio of less than 1 in 63% of cases, but incorrectly identified the speaker with the likelihood ratio in more than 1 in the other 37%. The report said of this: in summary, the system obtains the correct result for all the same speaker comparisons and for the majority of different speaker comparisons. When it does make an error, it is based towards the false identifications rather than false rejections. In other words, the bias would be towards acceptance of the prosecution rather than the defense's claims. In their second report, Professor French and Mr. Harrison had said that they agree with the view expressed in a research paper by Becker et al. 2012 that owing to possibility of errors made by the ASR systems in specific cases, it is necessary to accompany the ASR analysis with auditory and acoustic phonetic analysis. We would not use an ASR system as a standalone method for comparing speakers in a forensic case. In our view, it should be used in conjunction with a human-based auditory and acoustic phonetic analysis, which is what we have done in this case. In the light of their testing of the system and their use of it in this case, Professor French and Mr. Harrison gave evidence supporting that the use of BatVox, and by extension of ASR systems generally, in conjunction with other methods of analysis, as a reliable means of excluding a suspect's voice from any similarity with a questioned recording. They did not put it forward as capable of making a reliable positive identification of a suspect as the speaker whose voice could be heard in a questioned recording. The suggested advantages of ASR are that it is largely independent of the analysis who operates it, so that two persons processing the same recordings through the system should get the same result, that it produces a numerical estimation of likelihood, and that it compares the voice of the suspect not only with the question recording, but also with the reference population of the system. Neither Professor French nor Mr. Harrison was aware of any research or any academic articles which had concluded that the ASR systems were not reliable for court purposes, and it is said that such systems are used in court proceedings in many other countries. Professor French was asked why he would only use the BatVox system in conjunction with other forms of analysis, and not as a freestanding method. He said that the BatVox reflects mathematically the resonance characteristics of vocal tracks. That is the only aspect of the voice which is measured. It is possible that two men may have similar vocal tracks, but differ, for example, in accent or pitch. Therefore, use of the ASR alone could give a false hint. He accordingly felt it better to use BatVox in conjunction with testing of other characteristics which BatVox was not designed to test. He accepted in cross-examination that, whereas in relation to his conventional testings, he could explain to the jury what distinctive features he had found, in relation to BatVox, he could only explain that the system identified differences in the geometry of the vocal tracts, but he would not be able to say precisely what those differences were. He also said that some of the different ASR systems are more conservative than others, but he did not know which nor where BatVox was positioned on that spectrum. It was put to him that this would seem to raise the possibility of different systems producing different results. He accepted that, but he said that he did not expect that one would have one system producing a likelihood ratio below 1 and a different system producing a likelihood ratio above 1 in respect to the same sample. However, he concluded that in one of his tests, which compared the voice of Mr. Harrison with the voice of Mr. Pearman, the result had been a likelihood ratio of 0.8, and he further conceded that he could not say whether the different system might have given, for example, a likelihood ratio of 1.1. Professor French was asked why, in view of the claimed advantages of ASR, he had not used the system in any of his forensic casework apart from this case. He said that in this case, he had reference recordings of the known voices of the appellant speaking in the car. Without those, he would have felt it necessary to do wider testing on generic voices in cars before using the ASR as part of his analysis. In his evidence for the respondent, Mr. Reson made clear that although he has had many years of experience as a senior lecturer in phonetics in the City University of London, he has very little or no experience of actually using an ASR system. His objections are based on principle, not, as he openly accepted, on the technical knowledge of the machine. His objections therefore relate to all ASR systems. The nub of his objection is that it is asserted that the bat box relates to the geometry of the vocal cord, but he regards that as speculation. If it does so relate, then the properties of the vocal cords do not correspond directly to the sounds of speech. He regards the presentation in mathematical form as spurious science and a misleading portrayal of quantitative data. He was not satisfied there had been sufficient testing of the BatVox system because a proper evaluation would, in his view, require a comparison of hundreds of speech samples under conditions similar to those in this case. Although he was much criticised by the appellant's counsel on the grounds of lack of objectivity and the lack of expertise in relation to ASR systems, he was, in our view, entitled on the basis of his expertise in the field, generally to set out those objections of principle for the court's consideration. On behalf of the appellants, counsel submitted that the court should receive the evidence of Professor French and Mr. Harrison as fresh evidence pursuant to Section 23 of the 1968 Act. In accordance with the principles conveniently summarised in the case of Mr. Chatou, counsel submitted that the BatVox system should be admissible in evidence as an aid to existing methods of voice identification, even if not as a freestanding diagnostic method. They emphasised that the Crown, though well aware of the issues, had not sought to adduce any evidence to contradict the evidence of Professor French and Mr. Harrison as to the reliability of the operation of the system. They submitted that, consistently with Professor French's evidence, it may be that the system cannot be used as a positive identification of the speaker because it cannot express probability by reference to a large database, but it is, they submitted, capable of categoric exclusion. They argued that the evidence shows that, for that purpose, the system picks an appropriate sample and that no evidence had been adduced to the contrary. For the Crown, it was submitted by Mr. Greeny that the BatVox system was available to Professor French at the time of the trial. That accordingly, this is not fresh evidence and that the court should uphold the importance of one trial principle. Further, it was the appellants who sought to have this evidence admitted, and it was therefore for them to establish its admissibility, whether or not specific rival evidence was called. Mr. Greeny, in addition, put forward a number of reasons why the court should not regard the BatVox system as reliable, and should hold the evidence of the results of using that system to be inadmissible. He argued in particular that the BatVox results are expressed in a form of likelihood ratios, and that no clear basis for asserting that such is appropriate, and he invited the court to conclude that there are far too many variables and uncertainties in the data relied on by Professor French and Mr. Harrison for them to be permitted to express an opinion based on the use of a mathematical formula. In support of this last point, Mr. Greeny also relied on the decision of the Constitution of this court in T 2011 1CR APPR9, in which the issue was raised as to whether it is permissible to use mathematical formula and likelihood ratios based on statistics to arrive at an evaluative opinion in footwear mark cases. The court referred in that case to the permissible use in DNA cases of match of probabilities, not directed to whether DNA came from the suspect, but to the probability of obtaining a match that came from an unknown person who is unrelated to the suspect but has the same profile. The court continued at paragraph 78. However, no case was drawn to our attention which suggests that a mathematical formula is appropriate where it has no proper statistical basis. If there are reliable statistics and data, it would then be necessary to consider how the likelihood ratios should be used and how their use should be explained to the jury. The court then considered the reliability of the statistics and data in relation to footwear. It concluded that there were far too many uncertainties and variables in the data to enable an expert to express an opinion based on a mathematical formula, saying at paragraph 86, "There is no sufficiently reliable data on which the assessment based on data can properly be made for reasons we have given. An attempt to assess the degrees of probability where footwear could have made a mark based on figures relating to distribution is inherently unreliable and gives rise to a verisimilitude of mathematical probability based on data where it is not possible to build that data in a way that enables this to be done. None in truth exists for the reasons we have explained. We are satisfied that in the area of footwear evidence, no attempt can realistically be made in the generality of these cases to use a formula to calculate the probabilities. The practice has no sound basis." That conclusion made it unnecessary for the court to consider how, in the context of footwear impressions, the use of likelihood ratios should be explained to a jury. The court nonetheless referred briefly to Adams' 1996 2 CR APPR 467 and Tahini 1997 1 CR APPR 369 and Adams number 2 1998 1 CR APPR 377. A review of those cases led to the conclusion at paragraph 90 that we turn our conclusions about the aspect of the appeal. We would not think it right to refuse to receive the evidence of Professor French and Mr. Harrison solely on the ground that it was available at the time of trial. We accept the submissions of the appellant's counsel to the effect that it would be unfair to hold it against Professor French that he had taken time to test and research the system before deciding that he could properly use it in his forensic work. For other compelling reasons, however, we do not think it necessary or expedient in the interest of justice to admit the evidence of Professor French and Mr. Harrison, even accepting that their evidence is fresh evidence for the purposes of Section 23 of the 1968 Act. We find a number of areas of concern which lead us to conclude that the appellants have failed in this case to justify the use of a likelihood ratio generated by ASR software as a means of determining voice identification or exclusion. In view of our overall decision on other grounds of appeal, however, it is neither necessary nor appropriate for us to make any definitive ruling in this case as to whether such evidence can be ever admissible, or as to what position might be in the future in the light of any further scientific advance. We must, however, summarise the features of the evidence in this case which have caused us concern. First, we are far from persuaded that the very small reference population selected by the software provides a sufficient basis for a reliable conclusion. T emphasised the importance of a proper statistical basis if the use of likelihood ratios is to be justified. We accept the submission of the Crown that it has not been sufficiently convincingly demonstrated in this appeal that a group of 20 or 30 speakers adequately covers all the possible features of the geometry of human vocal cords. The outcome of the testing, in which a likelihood ratio of more than 1 was incorrectly found in over a third of tests, does not inspire confidence. Professor French gave evidence that he was not troubled by those results because he was not focusing on the use of the system to exclude rather than include a suspect. We do not share that response. Whichever way the error goes, it is an indication of fallibility which has not been satisfactorily explained. In the context of evidence which is said to enable the categorical exclusion of a suspect, on the basis of the comparison with the 20 or 30 speakers whose ages and accents may differ substantially from those of the suspects, such fallibility is troubling. The fact that the ASR systems are, as we were told, used for forensic purposes in other jurisdictions does not resolve those concerns, because we have heard no evidence as to the purpose for which the technology is used in those jurisdictions, and as to whether its use there is subject to any qualifications or limitations. Further, such jurisdictions might have quite different rules to evidence compared to those pertaining in England and Wales. Secondly, in a number of respects, it seems to us that the evidence ultimately amounts to little more than a bare assertion that the software is so designed as to ensure the right results, with no explanation of how the court can be confident that is so. For example, the selection by the software of the subset of voices from the reference population has not been explained, and no clear reason has been shown why the court should simply accept the assertion that the system has made the best choices. It does not seem to us to be a sufficient answer to this concern to say that it is only proposed that the ASR should be used in conjunction with other forms of analysis. In this case, indeed, it is apparent that Professor French was caused to adjust his opinions by the results of the Batvox test, which, in his words, took him beyond his original conclusion that the voice of M1 was very unlikely to be that of Mr. Pearman. It is also apparent that the Batvox results, amounting effectively to categorical exclusion or elimination with a fairly high degree of confidence, were inconsistent with the evidence of Mrs. McClelland and with the views so far as made known to this court of Dr. Holmes and Mr. Duckworth. The court therefore has to consider that it is being asked to admit what in actuality is advanced as decisive evidence, not simply supportive evidence. Thirdly, we are concerned that the counsel for the appellants were unable to give any satisfactory answer to the question of how the evidence of this nature should or could appropriately be presented to a jury. It seems that even a witness as distinguished as Professor French would in reality be telling a jury that the system had produced a certain result with no real explanation of what the features had contributed to that result, and therefore no real scope for cross-examination. How are the jury to evaluate such evidence? What, for example, are the jury to make of the proposition that the results of the Batvox tests are 38 times more likely if the suspect was not the man whose voice can be heard in the question recording than if he was? Are they to regard the 38 times more likely as a significantly high or significantly low? The absence of any satisfactory answer to such questions reflects the fact that the system simply produces a result expressed in a mathematical formula with the attendant danger of a potentially misleading appearance of certainty, but without any explanation of which features or similarities or dissimilarities have contributed to that result. Fourthly, it seems clear from the evidence before this court that different ASR systems may produce different results from testings of the same sample, if only because one system is more conservative than another. The submissions on behalf of the appellants were unable to satisfy us to how a jury should approach such conflict. Lastly, making every allowance for the proper wish to test the system and for the fact that the outcome of this appeal was awaited, it was not clear why Professor French and Mr. Harrison had not thus far used the Batvox system in any other trial or in any other casework, if only for their own purposes and by way of cross-checking on their other analysis. Professor French's answer on this, when raised to him, were, with respect, hesitant, nor was it clear to us why the fortuitous availability of the recordings in the Peugeot car was regarded as a reason to use the system in this case, even though it had not been used in other cases. These troubling features of the evidence suggested a certain lack of confidence in the system, and in particular to the adequacy of the system's own reference population. This is only reinforced by the instance that the evidence based on such a system should only be used in conjunction with other auditory recognition or acoustic evidence. For those reasons, we decline to admit this evidence, which in our view left many important questions unanswered. Although we have rejected many of the points advanced by the appellants, we have, for reasons stated earlier, overall come to our conclusions that these convictions are unsafe. They are therefore quashed. We have bore in mind that the jury were given a separate treatment direction at trial. They were not required to give like verdicts on all accounts. It might be said that, on one view, the handling court relating to the RS6 at all events potentially stood on a different footing from all other counts. Indeed, Mr. Pearman and Mr. Baxter at trial did not make any submissions of no case to answer on that count. But we note that the period specified in the indictment for that count was the same period as that specified for the count of conspiracy to murder. Accordingly, we do not think it right to reach any different conclusion on that count, nor did Mr. Greenery invite us to. We have also bore in mind that most of the new points and arguments addressed to us by reference to the schedules which we have been prepared to receive and accept related primarily to Mr. Baxter, albeit also to some extent by extension to Mr. Slade. At all events, not all of them by any means, we were directed to Mr. Pearman's position, but understandably in the circumstances, Mr. Greenery, as we have already indicated, did not seek to argue for a different outcome on these appeals as between the three appellants. We will receive the submissions of counsel of any consequential applications or other matters arising from this judgment when it has been handed down. Such submissions will need to extend to dealings with the outstanding appeals against sentence, which also include the appeal of Mr. Hudson. Dennis Slade, Richard Pearman and Michael Baxter were co-defendants wrongly convicted in August 2009 of conspiracy to commit murder in 2008 in Leeds, England, in addition to charges of criminal damage, arson and handling stolen goods. After their conviction by a jury, Leeds Crown Court Judge Paul Hoffman had sentenced all three to life imprisonment. If the convictions had stood, Mr. Slade would not have been eligible for parole until after serving at least 19 years, whilst Mr. Pearman and Mr. Baxter would not be eligible for parole until serving at least 17 years. In February 2015, the Court of Appeals, after looking over the case again with a clearer understanding of cell site analysis, as well as an in-depth professional conclusion from the barristers and the forensic specialists, had reversed the convictions after deciding that the convictions were unsafe of the three and ordered a retrial. In November 2015, at the retrial, the judge directed the jury to acquit the three defendants of all charges after the prosecution had discontinued its case after presenting evidence for a week during their retrial. The prosecutor told the judge, "We have conducted such a review in this case and have concluded that there is no longer any more evidence to present and therefore any realistic prospect of securing a conviction. Accordingly, we offer no further evidence." Mr. Slade, Mr. Pearman and Mr. Baxter were cleared of conspiracy to commit murder, criminal damage, arson and handling stolen goods. The three defendants still had to remain in prison but would be released much earlier than the original sentence which was given. The three were still serving sentences for convictions of robbery of a transit van in Warrington on March 8, 2006 and robbery of the Cross Gates Post Office in Leeds on December 12, 2007, as well as conspiracy to rob a cash delivery van at the Sainsbury's in Colton, Leeds. The court's appeal decision meant the minimum terms that each had to serve in custody were all significantly reduced. Mr. Slade's minimum term dropped to 10 years, making him eligible to apply to the parole board for release in March 2018. A parole board panel recommended Mr. Slade's release from jail at the hearing the following year. He was released with strict conditions which include wearing an electronically monitored tag. The parole board summary stated, "Evidence was presented regarding successful completion of accredited programs to address offending behavior. These courses had addressed areas including unhelpful thinking, understanding the effect of his actions upon his victims, and the use of violence." The panel heard how well Mr. Slade had demonstrated application of relevant skills and learning whilst in custody. Witnesses described good behaviour in prison, achieving trusted positions through hard work, being motivated to live an offence-free life in future, and that his risk factors and risk of future harm had been addressed through treatment programs. All witnesses present recommended Mr. Slade's release. Mr. Pearman was released from custody following a parole board hearing in July 2017. The parole board confirmed that a direction for Mr. Baxter's release was made in 2016. Soon after his release, Mr. Slade had more than £250,000 confiscated under the Proceeds of Crime Act. Mr. Slade was ordered to pay back the profits of his previous crimes, which were committed over a 3-year period across the north of England. Mr. Slade's confiscation hearing under the Proceeds of Crime Act was finally settled after apparent years of delay. Leeds Crown Court heard Mr. Slade had benefited to the sum of £267,836 as a result of his offending. The court heard that at the time 43-year-old Mr. Slade had assets available to repay the sum in full. The quashing of the convictions of Dennis Slade, Richard Pearman and Michael Baxter marks the dramatic conclusion of a complex legal battle for the notorious Slade Gang, with the elimination of the central plank of the prosecution's case against them. Their custodial terms were slashed, paving the way for their eventual freedom. Now all 3 men have regained their liberty, released back into society after years of incarnation. For their families, it is a moment of celebration and vindication. To their victims, it may seem an injustice, affirming the gang's elusive infamy. Yet the scale of the saga shows that justice is rarely black and white. Flaws in the original prosecution prompted a spotlight on the case, enabling the appeals process to catalyse their controversial release. The Slade Gang case stands as a sobering lesson for the police, prosecutors and courts. It reveals the need for exhaustive evidence gathering, ironclad arguments, and decisions sturdy enough to withstand fierce scrutiny. Most of all, it underlines the vital role of appeals in holding the system accountable. With Dennis Slade, Richard Pearman and Michael Baxter now walking free, the final chapter is written for the notorious Slade Gang, but the broader impact remains open-ended, potentially spurring reviews and new debates on British criminal justice's intricate workings.